heard appeal in the matter of Yehuda Tescher and Direct Accident Management Ltd and Spectra Drive Limited and AXA Insurance UK.
Thank you very much. Yes, good morning.
Good morning, my lords. Good morning, my lady. Yesterday, I was just turning to Giles and Thompson, the first of the three House of Lords decisions, and I was going to start at page 277 of the authority bundle, which is tab 2 of the case law. The significance of this case in my submission is it again emphasises the personal nature of a credit hire claim, personal to the claimant, and that the fact the credit hire company may have an interest in the outcome does not give it any interest in the litigation itself, still less an interest which excludes the claimant's personal interest. And the court will recall that yesterday a complaint of mine was that Mr. Malalou, I submitted, started his analysis in the wrong place, treating a claim for hire charges as if it were a claim that results purely from the hire company, whereas in fact it results from the claimant's attempt to mitigate the loss of use of their own vehicle. And at the risk of stating the obvious, I do ask the court to remember just how central a vehicle may be to many people's lives, especially to people who live outside large city centres, central to their working lives and their family lives. So in the present case, for example, the claimant in the Dams case lived in Tottenham, and he used his motorcycle for his work as a food courier. He was working for companies like Deliveroo. And the claimant in the Spectra case lived in Tingley, which, according to Google, is a village outside Wakefield. And she used her car not just for social and domestic purposes, but also for her work as a district nurse. And when she was deprived of it, she drove the hire car for just under 1,000 miles. So she was using her car to cover substantial distances on a weekly basis. So far as the Giles case is concerned, if, as I say, I'll take it up at page 77. Firstly, Lord Muster's analysis parallels some of the analysis I showed you later in the later House of Lords decisions. So by the marginal E, he says there are damages related to the loss of or damage to the motorist's vehicle. These will or may have two elements, a figure representing the diminution in value of the vehicle and another figure representing the financial loss suffered by the motorist because he or she cannot use the vehicle while it's either being replaced or if written off or undergoing repairs. These things are dealt with in various ways. He says the damage to the car is commonly settled between the insurers. Then he refers to possible excess claims and personal injury claims. And then he says, and I pick it back up at marginal G, there remains the claim for loss of use. In principle, if such a claim is made, it will often be quantified by reference to the cost of hiring a substitute vehicle. It obviously makes the point that you don't have to hire a substituted vehicle, it can just be quantified in that way. And will be recoverable upon proof that the motorist needed a replacement car while his own was off the road. I say if such a claim is made for two reasons. Firstly, because the loss of use is not recoverable under a comprehensive policy, so that there are no subrogated insurers to stand behind the claim. And in situations where there is no personal injury claim and where the damage to the motorist vehicle is dealt with as between insurers, there are few motorists who will have the time, energy and resources to go to law solely to recover the cost of a substitute vehicle. Secondly, because there are many motorists who lack the inclination or the ready cash to hire a substitute on the chance of recovering reimbursement for defendant's insurers. Thus, there exists in practical terms a gap in the remedies available to the motorist from which the errant driver and hence his insurers frequently profit. And Lord Muster's gap, and obviously it's a gap which the credit hire industry has come to fill, is vividly illustrated by the facts in the Spectra case. As we've heard, there was a road accident on the 23rd of October. AXA, to their credit, admitted liability within 5 days. But on the very day they admitted liability, they were sent the engineer's report valuing the car and giving its pre-accident value. But they didn't release an interim payment to enable Mrs. Smith to replace her car for 11 weeks. No explanation as to why a massive international insurer takes 11 weeks after an admission of liability and receipt of an engineer's report to release a cheque or to make a transfer. But were it not for the hire company, Spectra in that case, Mrs. Smith would have fallen into Lord Muster's gap. Now I come to the point that once a replacement, and I should say, and I'm just making those points again, not as some sort of cri de coeur, but just to show these are very much the claimant's claims. These are claimants that need vehicles to continue their lives. Next come to the point that, yes, once a replacement vehicle is actually hired, then as I showed you yesterday, and it hardly have come as a surprise because I appreciate it's very elementary law of damages, that crystallises a special damages claim as the liability to be made in these costs applications, that really they can be assimilated to subrogated claims, but fall wide of the mark. And as we're going to see in Giles and Thompson, Lord Muster specifically says these are not subrogated claims in law, they are the claimant's claims. But before I come to what's said in Giles, I want to contextualise it, if I may, by at this point listing as I have to the actual hire agreements which Mr. Maloloo showed you yesterday. So if I can take the one in the DAMS case first, which is in the core bundle at page 114. So Mr. Maloloo, I think, began by showing you clause 5 at page 114. So clause 5, Roman 1, that's the deferment. So the rubric is where the hire is consequent on an accident. Roman 1, that's the credit period. You get a deferment until the conclusion of the claim, or there's a long stop period. And then Roman 2, the hirer shall diligently pursue a claim for the hire charges against the third party, and shall appoint solicitors nominated by the lessor for this purpose. The hirer shall thereafter use all reasonable endeavours to recover the hire charges from the third party, and should fully cooperate with the lessor and the appointed solicitors. Now, obviously, that imposes obligations upon the hirer, and then clause 6 allows the agreement to be terminated, or the deferred payment facility to be terminated if the client is in breach of those requirements. And I'll come on to how that should be approached in a moment. But I do, if I may, also want to refer to clause 10, which Mr. Maloloo referred you to, in this case slightly half-heartedly, because he accepted that clause 10 is really connected to damage to the hire vehicle and isn't really focusing on the underlying claim. But if anything, Mr. Maloloo went too far even by being half-hearted. He shouldn't have had any sort of heart. Because if you put this into context, clause 9, clauses 5 and 6 deal with the payment obligations. Then clause 7 just deals with the daily rate of hire. Clause 8 then is a payment on demand clause. Clause 9 then comes on to care of the hire vehicle. So if you don't arrange your own insurance, the lessor will insure it. That's subject to an excess. Then there's a reference to the excess being potentially waivable, a CDW, which is, the court will know, you see all these things in hire agreements, not just credit hire agreements, all of them really. And then there's a requirement of the policy, every accident, no matter how minor, is reported, and that accident report form is completed within 24 hours. Then there are obligations to obtain names and addresses, not to make admissions, all completely commonplace things in hire agreements. And so when clause 10, and then there's a reference to delivering summonses, writs and documents received, and to cooperate fully with the lessor and insurance company in the investigation and defence of any claim. That, of course, means a claim against the hirer or DAMS itself, because their car has been involved in an accident. And so when clause 10 says the hirer will, at the request of the lessor, do all required by the lessor and permit his name to be used by the lessor for enforcing any rights or remedies against the parties in connection with the vehicle, that is a reference to the hire vehicle. And it's all about if the claimant has an unconnected accident when he's out and about in DAMS's car. This has got nothing to do with the underlying claim. As I say, Mr. Maloloo almost concedes, but doesn't quite. But he really is taking that completely out of context. This is all in the context of if there is an accident, which is addressed by the previous clause, involving the hire car, that in those circumstances, the hirer will assist DAMS, and in those circumstances permit his name to be used for enforcing any rights or remedies in connection with the hire vehicle. So
you say it's just sloppy drafting by your clients, because it should say hire vehicle, which is the expression then used in clause 11.
They do say hire vehicle in the next clause. You're absolutely right about that, and it would have been better. I'm not so sure I would go so far as to call it sloppy drafting. I mean, it may get a bronze star rather than a gold star, but yes, I take your...
Because hire vehicle is then the subject of clauses 11 and 12.
Yes. But I mean, for example, at clause 3, the hire undertakes to return the vehicle in a clean condition. That's obviously also a reference to the hire vehicle. So the agreement isn't as consistent as it might be. But I do say, in context, it's absolutely obvious that that has got nothing to do with the claim against the tortfeasor. So what do I say about the obligations earlier in the agreement in clause 5 and 6? Firstly, I say, well, they're just completely unremarkable. I mean, if you say to somebody, well, I will, since you've told me you are going to be bringing a claim against a third party, I will defer your liability to pay until the conclusion of that claim. It's hardly surprising that the agreement says, but if you don't pursue that claim, then I'm not going to defer your payment anymore. It's not it's not in any sense a remarkable or sort of coercive provision. It's one that follows as night follows day, I would submit.
Well, you say it's not coercive. Well, but if one looks at 5.2, I commented yesterday, it's the shalls, it's mandatory.
Well, it is mandatory in that the claimant has applied to have a hire car which they don't want to pay for immediately because they say that somebody else is to blame for the damage to my car, and for the hire agreement to say, well, yes, we are prepared to rent to you on those terms, but in those circumstances you will pursue the claim that you've said that you'll pursue. When I say it's coercive, I mean it's not forcing the claimant to do anything. It's simply reflecting the very bargain which the claimant elected to enter. Obviously, there's an elective decision by the claimants because they need cars and can't afford them for a conventional hire company to take cars on these terms themselves. But what Mr. Manilow is saying, well, this is the reality is on these provisions, the defendants aren't merely riding two horses. They're riding two horses, one of which is riding north and the other one is riding south, because they simultaneously say that, oh, see, Mr. Justice Ritchie, all this is just an illusion because the claimants have never got any money to pay. And they also simultaneously say, oh, this is a highly effective way by which the hire companies control the claims. And the reality is all it is a provision that says, if you don't keep to the basis on which you asked for when we granted credit, then you lose your right to credit. And that's the extent of it. It just gives the hire company a right to damages, which may very well be illusory, as Mr. Manilow in different parts of his argument wants to emphasise. And to say that is a...
Mr. Williams, do you accept that it's relevant when considering these clauses that this is a contract been entered into with someone who is ex hypothesi impecunious?
Well, I mean, if it was suggested, for example, that there were unfair terms or terms in breach of the Consumer Rights Act or something like that, the fact the claimant was a person I mean, she's a district nurse, I don't want to overstate it, but a person of perhaps relative commercial unsophistication, would obviously potentially be relevant to the fairness of terms, but there's never been suggested that anything in these terms are unfair.
No, that's not what I'm talking about. My understanding is that there's no dispute that the way this works is that the individual, the hirer, is impecunious.
Yes.
That's why credit hire rates are higher
yes.
than the rates that are not impecunious
yes.
person.
Yes.
And it at least struck me as being relevant when considering what the overall effect of these terms is, to bear that in mind.
Well, I mean, that's not I don't disagree with that.
I didn't think you did, but it sounded like you just did
but,
there, which is why I emphasised
well,
it.
very good. Thank you, my lord. I'm sorry if I was
all.
unnecessarily defensive. But what I was going... So my submission is that this is it's an unexceptional term. It's almost impossible to imagine how this transaction could work without a term like that. What I would suggest, it is absolutely the bare minimum. You can consider here what is absent. What this agreement might have had express contractual rights of the sort that you would find in most insurance policies, for example, that does grant the company a contractual right essentially to take over the case and to use the claimant's name to litigate. It might have granted the company not merely a right to nominate a solicitor, but a right actually to give the solicitor instructions, or a right to compromise the claim, for example. Or it might have given the hire company some sort of security over the proceeds of the claim by signing it, or something of that sort. All rights, as I say, insurers commonly have. And also some of those rights, what you'll typically see in a litigation funding agreement, for example, the litigation funder, the proceeds of the litigation is put into trust. A trust is created over the proceeds of the litigation for which the funder is the beneficiary. And if you had all that sort of paraphernalia, then I entirely accept subject to maybe arguments about causation, this case would look different. But what I say is all of that paraphernalia is absent. Interestingly, it's not absent in some of the cases which my learned friend relies on. But what we simply have here is the only coercive mechanism, if such it be, of the company is to say, well, if you break your bargain that you've said to us, you're going to pay us out of the proceeds of the claim because you don't bring one, is at that point our charges become payable. And that's it. They can't step into the claimant's shoes. They can't give instructions to the solicitors. So in my respectful submission, although Mr. Manilow put a great deal of emphasis on all of this, this is absolutely the least coercive agreement one could possibly have. And this really is a mandate for saying, well, it's simply impossible to provide post-accident assistance to impecunious people on what Mr. Manilow's called non-recourse terms without making yourself liable for a cost order. And if that's right, as I say, it would have very troubling consequences, not least for every lawyer who acts on the CFA. Can I also perhaps at this point deal with the fact that some emphasis is put on that DAMS is in common ownership with Bond Turner, who were the claimant's solicitors. In my respectful submission, that makes absolutely no difference, absent it being suggested that as a result of that common ownership, Bond Turner in some way treated their clients differently from any clients, subordinate in some way, weren't really acting for them, subordinated their interests or anything of that sort. Weren't independent, shared information with the hire company they weren't allowed to share with them. There's no suggestion of any of that. Mr. Manilow is fastidious in eschewing any suggestion of impropriety. The evidence of DAMS, which I don't think I've got time to turn up, but can I invite the court, and I'm sorry to place a burden on it, just for its note, the statement of Paul Levens, which the district judge accepted in its entirety, and there is no real appeal from him saying, from him accepting the evidence, is at page 141 of the supplemental bundle in the DAMS case. If I could respectfully invite the court to read that statement, it's quite short. Essentially, what Paul Levens says is we don't force people to use Bond Turner, albeit if they say we don't want to use Bond Turner, we might take the decision not to hire them a car. Most claimants are happy to use Bond Turner, and we send the case off to Bond Turner, and I paraphrase, but we let Bond Turner get on with it. They don't share any information. We don't even see the claims documents. We're not consulted about settlement. We're not consulted about whether proceedings are commenced. We simply get our recovery at the end of the case. And I'd also make the point in this context.
Sorry, just a minute, Mr. Williams.
Yes.
You just said the evidence about the appointment of the solicitors, but the clause you draw attention to says the hirer shall appoint solicitors nominated by the lessor.
Yes, it does say that. But as I say, her evidence is that, well, I mean, in this sense, as she does say in her evidence, if a claimant says, well, we don't want to instruct the solicitor you've suggested, in those circumstances, they will often not proceed with the bargain, but the evidence is actually sometimes they will if the claimant suggests a solicitor who they think has got the skill set. I'm paraphrasing that slightly, okay. But as your lordship will appreciate, it's hardly unusual for the strict terms of contract, you know, sometimes not to reflect the real world performance. Just a final point. Obviously, things like joint ventures between firms of lawyers and other businesses and such, they're still relatively new. But it is perhaps worth remembering that this was all express government policy in enabling firms of solicitors to be owned by non-lawyers and to be parts of bigger corporate groups, was a core policy of the Legal Services Act 2007. It is now commonplace, and I don't say this in any sort of negative sense. I mean, just an illustration of that is the major firm of solicitors that represents the defendants in the Spectra case, Keogh's, very well-respected firm. They are themselves part of a much larger insurance services conglomerate called Davies Group, which is a major Anglo-American conglomerate. So though it may still be relatively exotic, particularly to you know, those of us who were in practice before any of this was allowed, I mean, these days it is commonplace, and Mr. Manilow accepts there's nothing outlandish about it. So can I then come to the Spectra documents? Of course, there's just a single bundle in that case, and it's page 232.
Page which, sorry?
Page 232, my lord.
Thank you.
So, just for completeness, I don't think Mr. Malilou showed you clause 5, but that's the first clause that refers to a reference to the accident, to an accident. So where the hire is consequent upon your own vehicle being unroadworthy as a result of the accident, and the claim for damages is being or is to be pursued, you agree to pay us in a single payment at the conclusion of the action, ... So there's the deferment facility in the event of an accident. And clause 5 itself doesn't impose any active obligation on the part of the claimant actually to pursue a claim, but it simply means the pursuit of a claim is the quid pro quo for the deferment facility. So that's really the extent of clause 5. Mr. Malilou then showed you clause 10. And this was a curiosity in his submissions, because whereas in the DAMS case he accepted clause 10 actually related or primarily related to accidents in the hire car, in this agreement he presented an almost identical clause as relating to something different. But he's wrong about it. But he's simply wrong about that. This is again directed at accidents in the hire vehicle. So when Ted says you will at our request do all required by us and permit his name to be used by us for enforcing rights or remedies against the parties in connection with the vehicle. Again, if you contextualise that, you'll see this is in a section of the agreement which deals in identical terms almost to the DAMS agreement with accident, the need to insure the hire car and what you do in the event there's an accident in the hire car. And then it's followed clause 11 by another clause which deals with insuring the hire vehicles. So this is all in the context of the claimant's duties in respect of the hire vehicle. And again, in my submission, respectful submission, Mr. Malilou misdeploys that clause. So it's the same point as I've made on DAMS. And then Mr. Malilou focuses on the termination rights. It must be said here the agreement is in a terrible muddle in places. Well, you'll have already noted how mysteriously similar it seems to be to the DAMS agreement. It's pretty obvious that this agreement, in fact, has been cut and pasted from multiple sources because there are cross-references, as Mr. Malilou pointed out, to clauses that don't agree. That don't exist. What we also have in these sections is the agreement starts talking about liability to pay repair charges. Now, there are some credit hire companies that provide a repairing service, and you have a vehicle hire and repair agreement. But this is just a vehicle hire agreement, so the sudden appearance here of repair charges is another clear sign that there's been some cut and pasting from somewhere else. But I mean, what this basically is what really my submissions are the same. This is a right to terminate if there is a breach of the vehicle, a breach of the agreement. If there is such a breach, they can repossess the hire vehicle. Well, that's hardly surprising. And insofar as the agreement gives them a right to instruct the body shop to stop work on your own vehicle and exercise a lien. Well, I mean, that's an interesting ambition for them to have in circumstances where they aren't actually providing vehicle repairs. That seems to be an artifact of the cutting and pasting. But be that as it may, I make the same points in respect of this agreement as in respect of the others. I mean, ultimately, the only, in inverted commas, coercive power is to say, well, if you don't keep up with the fact you've negotiated a deferment to pursue a claim, if you don't pursue the claim, you lose the deferment. And that's the full extent of it. And I essentially adopt the submissions I've made in respect of DAMS. There's then the form of authority and mitigation questionnaire, which we have 2 pages on at 234. Mr. Malilou referred you to that. That's the one where the signature's in the wrong place, if you recall. So what that does is it authorises, first of all, it's a Mrs. Smith's request. So again, this is something she's requesting, a Spectra to recover her uninsured losses arising from a road accident and to appoint a solicitor. But the evidence in this case, and the circuit judge's finding, is that here they did not appoint a solicitor. That was appointed by the claimant on the advice of a different claims management company. It specifically acknowledges that she does have the solicitor the right to instruct a solicitor if she wants to of her own. That's essentially what she did. She agrees not to accept any settlement of her claim other than from the company or the solicitor. she authorises the solicitor to disclose to the company details of offers or developments relating to my claim, so it's an obligation to keep them informed, and she undertakes to cooperate. But here, again, we don't have any right on the part of Spectra to give instructions, to step into the claimant's shoes, to use her name, no security interest or assignment over the proceeds of the damages or anything like that. So again, my submission is there ultimately has to be some quid pro quo. If you're going to walk into a business and say, look, I need a hire car, I can't afford one. Will you lend me your car, probably worth many thousands of pounds, and let me not pay it, and then let me not pay for it while I pursue someone else? It's just an inevitable incident to that the hire company is going to have to impose some obligation for somebody else to be pursued in a diligent way. But that is the extent of it, and it certainly does not, in my respectful submission, make the hire company anything like a shadow party to the litigation, still less give it any rights to control the litigation. And of course, in this case, it's now common ground, for example, that this litigation was discontinued, and Spectra wasn't even told about it. There's still less consulted. So, I mean, it's not controlled, as a matter of actuality, there's no suggestion it's actually controlling the litigation in any way. So with that detour, can I just come back to how these sorts of points are treated in Giles, where the agreement, some of the hire agreements, there are two hire agreements in Giles, they have some similarities, but they also have some quite significant differences, and they do go a bit further to being sort of giving quasi rights of subrogation. And if I can just, obviously I don't want to take too much time on it because you're not deciding Giles, it was decided some years ago, but it does contextualise what Lord Mustle goes on to say, because notwithstanding these agreements actually do give the hire companies much greater rights, Lord Mustle still goes on to dismiss the defendant's assertions that rendered the hire agreements intermeddlers or in any way rendered them the true plaintiffs. Obviously, that wasn't in the cost context, it was in the Champity context, but nevertheless, he's construing agreements which give the companies greater rights than the two companies that are before your lordships and your ladyship. And as a matter of construction, the House of Lords finds that these agreements simply do not give the hire companies the influence over the litigation that's being asserted against them. So the first case is a case called Devlin, and the agreement there is set out at 80 of the of the authorities bundle. And what you've got, you see even the numbering is not dissimilar. So it's this by marginal C, clause 5, as it is, where the hire is consequent on the hirer's own vehicle being unroadworthy as a result of an RTA, the lessor will allow the hirer credit on the hire charges, etc., etc. But here we do have some additional rights. So at Roman 2, the lessor shall have the right to pursue an action in the hirer's name against the third party. Roman 3, the lessor shall have the right to pursue such action through the county court and or high court, and the hirer must cooperate in the conduct of the action, and if required by the lessor, attend any hearing the court appoints. And then at 6, again, if they're in default of that, we can terminate the credit. Then at the bottom of the page, there is a reference to a form of authority in that case as well, not that dissimilar to the point in Spectra. So this is marginal G. So that form of authority again contained two provisions. Firstly, the right to appoint a solicitor to act on the motorist's behalf. But I understand I'm at liberty to appoint any solicitor to act on my behalf. So again, it's very similar to the Spectra form of authority. As with Spectra, that clause wasn't invoked, so it was actually struck through. But the facts of Spectra are the same in that they didn't appoint a solicitor. And then the second part says, I hereby authorise you, the third-party insurers, in this matter to release to my solicitor a separate cheque to be made payable to First Automotive, that's the hire company. Then in the Giles case, the agreement is set out at 81 marginal G. Again, the terms are similar, and I'm just going to make the same point about them actually giving the hire company rather augmented rights over the action. So you'll see at 2, the company shall have the right to appoint its own solicitor to pursue an action in the hirer's name. So that really does look like a contractual right to subrogate. And at 3, the company's solicitor shall have the right to pursue such action through the county court, and the hirer must cooperate in the conduct of the action, and if required by the company solicitor, attend any hearing. And then again, you have the termination. It may or may not be worth noting that another distinction from the agreement in Giles is that it is expressly no win, no fee. If you get to clause 1, where the hire is consequent upon the hirer's own vehicle being unroaded as a result of the accident, the company will allow the hirer credit on hire charges until such time as damages and interest have been recovered. So unless damages are recovered, there's never a crystallised liability. And here too, my lords, my lady, there is a separate authority form which is quoted at 82B. I confirm you may appoint a solicitor or legal agent on my behalf to act in the recovery. They will also act on my behalf for the recovery of any personal injury or other losses. They've my authority to commence proceedings if necessary. So that goes further than our 2 cases. For recovery of the hire charges and to apply for medical evidence. And then she, I can't remember if Giles was a he or a she, but they confirmed that they haven't instructed anybody else. So if one sees then what Lord Mustall made of those greater rights, he addresses Devlin at 83D. So he says, what rights does the company possess? This is just below C, in fact. What rights does the company possess in the sums recovered by the motorist from the defendant? The answer is plainly none.
Sorry, which page are you on?
83, my lord.
83?
Yes, just below marginal C.
Yes. In the context of the issue as to whether the contract was unlawful.
Yes.
Because that was the issue. I mean, having looked at the issues from 82 on to 83, the issues were whether those contracts were unlawful.
Oh, quite.
And the House of Lords concluded they weren't for the reasons given. So it's a very different issue.
Well, it's a different context, but the construction of the agreements obviously is not determined by by what the issue is. I mean, either
no,
the
but nobody's suggesting that the agreements in this case were shamputous and therefore.
No, but it is being suggested essentially that the hire company is the true party.
Well, that's a different. Well, I think it's being suggested their hire company is a real party.
Yes.
Speaking entirely for myself, I do think they're potentially, at any rate, very different issues. I mean, I understand why you're referring to this and the points that you get from it, but we do need to be aware that what Lord Mustall is talking about here is all under the heading 3, are the contracts unlawful?
Obviously, with respect, my lord, you're absolutely right about that, of course, and I don't dissent from any of that, and I'll paint with a light touch, but I do say it's nonetheless important when, for example, defendants and to some extent the practice direction are trying to assimilate these cases, for example, to subrogated claims. That we have a decision of the House of Lords specifically in the corner in the context of credit hire, which really explodes those assertions by really making it absolutely clear that the claim always remains the claimant's claim.
Well, I understand that point.
So yes, I'm
okay. So that's the passage at 83 by the first hole punch.
83. Yeah, I have an electronic bundle, but it's C to D essentially.
Okay.
It's below C, next to D.
Old-fashioned reference.
Yes,
sorry.
forgive me, my lord. No, I wasn't intending. Wasn't intending to just to explain why I might have been obtuse in not being able to say where the hole punch was. Yeah, so that's just making it clear that. That they don't have any sort of charge over the proceeds. The proceeds belong to the claimant. Now, it might have been an indication that the hire company had become a real party if they actually had proprietary or security rights over the proceeds, but they don't. There's no assignment and such like. So that's 83D. So far as Giles is concerned,
Isn't there one of the contracts I've forgotten which may not be Devlin, it may be the other one? Say basically the money has to go to the company or the solicitors first.
well, obviously Lord Mustall simply thought that didn't give them I mean, I suppose that would mean they'd have a right to breach of contract if the claimant dissipated the money, but he's finding it, he clearly was of the view that didn't create an assignment, for example.
Okay.
But I mean, I can understand that the contrary might have been argued, but it's a decision of the House of Lords that dismisses that as a proposition. Mm-hmm. So in Giles, the equivalent passage is the bottom of 83 to the top of 84, I think. No, I'm wrong about that. Sorry, let me just look at my note. No, sorry, I'm a page out. It's the bottom of 80. It is the bottom of 84, where he says the companies have no interest, whether by charge or assignment, which give them any claim to the proceeds, nor is any part of the recovery shared with the motorist. They don't have a preferential claim against other creditors. The position is simply, and this I do perhaps put slightly more emphasis on at the top of 85. The position is simply that the success of this part of the claim will equip the motorist with extra money from which the higher charges can be satisfied. And in my respectful submission, that is absolutely spot on, if I can respectfully say so. That is all we have here. Claimants need cars. They go to hire companies and say, I'm proposing to bring a claim, can I include your hire charges in it? And the hire company says, yes, you can, and because of that, we'll let you defer payment. And they leave the claimants to get on with the claims. And the result of the claim isn't that the hire company has any rights over the damages, it simply equips the claimant with funds to pay them. And in my respectful submission, that does not make the hire company a real party. Sorry, the reason I'm being slightly hesitant is in the light of my Lord Justice Coulson's indication. I'm just skipping some passages which I might otherwise not have, might have referred to. I think, if I may, I will just show the court also something that's said at 88. Because this is not least because I say this helpfully identifies why Mr. Malilou's comparison with the litigation funding agreement is a false one. So at 88G, on the right-hand side of the page, there's a sentence that begins, the company. The company makes its profits from the hiring, not from the litigation. It does not divide the spoils, but relies upon the fruits of the litigation as a source from which the motorist can satisfy his or her liability for the provision of a genuine service external to the litigation. I can see no convincing reason for saying that as between the part, well, and this goes on as that, therefore it's lawful, and that's not relevant to our case. But the point is that, yes, this is not a company making its profits from litigation, it is making its profits from the hiring. And then that ties into Lord Mustall's next conclusion over the page, where he rejects the proposition that all you have here is a right to recoupment out of damages, so that the claimants don't have an interest in the cases themselves. And that's by marginal F. The defendants are forced to contend that the consideration for the provision of the cars consisted solely of a right to recoup themselves from the damages for loss of use. I do not accept this interpretation. The hiring company has no direct right to the damages. The company is not an assignee or the chargee of the cause of action or its fruits, although it expects the damages for loss of use will form part of the assets from which the motorist can in due course pay for the substitute. The liability for the car hire, although suspended as regards enforcement, rests upon the motorist throughout. It is a real liability, the occurring of which constitutes a real loss to the motorist. Whatever publicity material might have conveyed, the provision of the substitute cars is not free. And so if I can just here enlarge on the distinction from litigation funders. Litigation funders do make their money out of investing speculatively in the litigation itself, and they divide the spoils of the litigation. They are, in that sense, in the traditional terminology, intermeddlers. And their agreements, of course, were traditionally characterised as champertus, and their exposure to cost orders is simply a quid pro quo that results from such arrangements now being allowed. But being champertus intermeddlers is the very thing which Lord Mustall finds in Giles and Thompson that credit hire companies are not. But that's what they were being accused of. You were champertus intermeddlers, and that's the very allegation that was rejected. And it's also, I would suggest, the reason why litigation funders are exposed to non-party cost orders, but solicitors and barristers who operate on CFAs are not. Again, the solicitors and barristers, yes, they're actually closer than the hire company to the litigation because they are providing litigation services and they're managing it. And to that extent, they do make their income out of the litigation. But they nonetheless are providing professional services, and they're not dividing the spoils of the litigation, albeit the litigation may, because it ends up with a cost order, ultimately provides the claimant with the funds from which they can be paid. So it is an analogous situation. They are not exposed to cost orders in the way that litigation funders are. And I'm saying that hire companies are much more in the position of solicitors and barristers, except they are further from the litigation because they're not making their money out of the litigation at all. They're making their money out of the provision of a hire car. Can I also, while I'm dealing with litigation funders, just deal briefly with the point Mr. Manilu made here about causation and litigation funders? He says, well, one of the reasons why the other side are obviously overstating causation is because you don't see causation really as an issue in the cases where there are cost orders against funders. But if that's right, and I can't say there aren't actually that many cases where cost orders have been applied for against funders because they usually just concede their liability given the state of the law. But it's hardly surprising if it is right, because you obviously only go for third-party cost orders if the party itself can't pay, either because it's impecunious or it doesn't have ATE insurance. And so you only go after the non-party because the party can't pay. And if the party can't pay, then it's practically inevitable that the litigation funder would have facilitated litigation that couldn't otherwise have been brought. And it just as night follows day. So the absence of a debate about causation in supposed absence in funding authorities is hardly surprising, because it's just going to be self-evident. The whole point is that they facilitate litigation that couldn't otherwise be brought. Before leaving Giles and Thompson, if I can just, I've got to deal, I think, just for the court's note, because I won't labour the point in the light of my Lord's sort of courteous chivying of me on. Page 90 is the point at which Lord Mustill says these are not subrogated claims. And he makes the point that obviously the key to a subrogated claim, for example, is that the insurer has got rights to take it over and control it, and actually does have rights over the proceeds. In strict legal terms, it has an equitable lien over the proceeds of a subrogated claim, and obviously he's rejected all of that here.
Is that page 90?
That's page 90.
Where about?
Unless I've got my note wrong. Oh, it might be 91. Sorry, it begins at the foot of page 90 and it goes into, and the real meat of the discussion is 91. And the
91 E to
H. E to the top of H.
Yeah.
It's also, and I didn't pretend it's anything more than a tiny point, but also this whole passage is about, well, you can't get interest in credit hire cases because the claimant's not out of pocket. And again, I mean, that's another, it's maybe a pretty small indication, but it's another actually indication it's the claimant's claim. The credit hire company is out of pocket. I mean, it hasn't been paid for, some of these cases take years to litigate, but you don't get interest because the claimant's not out of pocket, it remains their claim. Mr. Manilu did refer to the passage at page 88 where Lord Mustill talks about the salutary impact of claims failing and consequent cost orders and imposing a healthy discipline upon the companies. That's obviously not a reference to non-party cost orders, and not least because in 1994 they were like hen's teeth. And in fact, it was still then largely thought they were reserved for cases of impropriety. Obviously, the jurisdiction really exploded after the Dymox case in the Privy Council a decade later. It obviously does impose a discipline on the hire companies where claims fail. The documents from DAMS that you were shown yesterday show that claims failing is very rare, which in fact makes the point that these aren't speculators. They're companies providing services to motorists with very solid claims, but who otherwise, due to their lack of means, would fall into Lord Mustill's gap. So the reference to cost orders here is to cost orders against the claimants, but the hire companies in Giles were funding the claimants. Now, in these cases, there is no funding, but as I explained yesterday, what there will have been is ATE insurance. And certainly in the DAMS case, as I said, the documents Mr. Manilu showed you yesterday, they go on at some length about the ATE cover, which DAMS, the ATE services, which DAMS also provides. ATE cover, of course, didn't exist back in 1994. It came in with CFAs a few years later. And it takes me back to the point here, the problem here isn't that, the problem here is that the defendants do have cost orders against the claimants. And it's not a question of the hire company cynically leaving the claimants in the lurch, undefended against those cost orders because they would have had ATE insurance. But the point is the defendants can't enforce those cost orders because of quox, and that takes me back to really what all of this about is an attempt by motor insurers having pocketed the benefits of the Jackson reforms, of which quox was the quid pro quo, just really trying to transfer the losses which they suffer as a result of quox as far as possible onto the hire companies. That's what it's really about. Can I lastly, just at this point, also, I said yesterday that another telling feature that these are really, that these are quite clearly the claimant's claims. And I think I characterise the defendants as practising a form of what I called cakeism, because when it comes to the damages cases, the damages stage of the cases, they're only too happy to stress that the claimant needs to prove an enforceable liability and such like. Is just again for the court's note, I visited overnight the defences in the two cases which we do have. In the DAMS case, it's core bundle page 107, paragraphs 15 and 16. Page 107, paragraphs 15 and 16. And in the Spectra case, it's page 224, at paragraphs 23 to 25. And in fact, maybe it is just worth turning up. I'll just turn up the Spectra defence. So that's page 225 of the Spectra bundle. No, in fact, it's 224. I apologise. So at page 224, you'll see in the defence there's actually a heading enforceability. The claimant is put to proof they have a personal liability to pay the credit hire company, any sums at all. They're asked to clarify the name of the person who signed the hire agreements and disclose full copies of the hire documentation, copies of all correspondence with the credit hire organisation, the person who signed the agreements, no admission as to enforceability. Then they go further even than pure contractual enforceability. 24, claimant is put to proof as to the representations made to her by the hire company or solicitors, documents in their possession, and their understanding of the contract at the point of signing. If the claimant entered any of the contracts relying on a misrepresentation, innocent, negligent, or otherwise, the agreement's avoidable. Presumably, they then say it's a failure of mitigate, not to void, I suppose. Further, should the claimant have a different understanding of the contracts than that of the hire company, or could not reasonably be aware of the terms and conditions, it cannot be said the claimant was intending to be legally bound. So that's a sort of non-est factum point they're raising. And the contract falls in construction. And then they go yet further and they raise the Consumer Rights Act at paragraph 25. Now, obviously, nothing came of any of these points in these cases. But again, I do respectfully say, firstly, it drives home the point that not just as a matter of law, but as a matter of practice, these are claims by the claimants, which the defendants vigorously contest on the basis the claimants may not have a liability to pay. And in my respectful submission, they're inviting a development in the law which makes the law incoherent if they say, well, having made all those points at the damages stage of the claim, at the cost stage of the claim, we turn around and say, oh, actually, this was always the hire company's case. The claimant is nominal in both senses of that term. The hire company is the real party. That really is having the cake and eating it in my submission. My Lords, I appreciate I'm moving quite briskly, but I am concerned about the time, and Mr. Mallory has rightly reminded me that he does need some time to reply. So I am going to, if I, at certain points, just deal relatively elusively to my skeleton and also to some bundle references, and I hope that isn't...
Right. Can we put the authorities away?
Well, no, I'm going to be coming to some more authorities shortly.
All right, but away for the moment.
Well, really not for very long, because but what I was going to do is I know I've said repeatedly, I've repeatedly drawn a parallel with solicitors and barristers on CFAs and other no-win, no-fee instances. Can I just say that is addressed in our Tescher skeleton at paragraph, and our DAML skeleton at paragraph 6. Other examples include, for example, after the event insurers. They're only paid their premiums if their insured wins the case. It's never been suggested that because they are no win, no fee, they are exposed to non-party cost orders. And that could happen, of course, because what you might get is a case where, for example, if the claim has been found fraudulent, the insurer won't pay because on ordinary insurance principles. So you might say, well, the insurer nevertheless facilitated the litigation through their no-win, no-fee agreement. But no one has ever said that. And as I've said, so far as barristers and solicitors are concerned, this court has decided that the fact they are acting no-win, no-fee emphatically does not expose them to non-party cost orders. And that because
as a matter of principle that without more, simply
Without
acting,
more.
without more,
Yeah.
because you can see plenty of circumstances in which no win, no fee arrangements, conditional fee arrangements might give rise to NPCOs. But those would, because there would be a range of facts.
Well, an example. Sorry,
But
I thought you were finished.
your point is there's no authority of which you're aware in which the mere fact that acting on a no win, no fee triggers an NPCO, and in fact there's authority the other way.
Well, I was going to say it goes slightly further than the first way your lordship put it, because there's authority that says it does not.
Yes.
And
fine.
just for that's
but that's without more.
That's without more. And an example of more is, of course, the Myatt case Mr. Manilow showed you yesterday, where the solicitors sponsored an appeal after their CFA had been found unlawful, and they were the party who was essentially, at that point, the court says, at that point you're singing for your supper, putting it crudely, and you've stepped outside the protection of the general principle. But I'm not sure I'd go as far as your lordship in saying that, or implying such cases are commonplace. I mean, I think Myatt is the only example that generally has been identified of a solicitor acting on a CFA being ordered to pay costs. As I said, the first authority to establish that no win, no fee agreements without more it does not expose a party to an un-party cost order is the case of Hodgson, which for the court to note it's tab 6. And the page number, the references within the bundle are page 199 at G and 201 at H. And it's Lord Wolfe. There are sequels to Hodgson, which we haven't put in the bundle because it just won't be controversial between Mr. Manilow and myself. For example, there's a subsequent case where the solicitors also funded all their clients' disbursements under the CFA, and that was held not to change the principle in any way. So even if you are actively putting up money, not merely deferring your own charges, that's been held not to alter the Hodgson principle. My lords, I was then now going to turn to making submissions on the real party, the concept of the real party. And that is going to take me to the Dymox case. So I just need to go back into my authority bundle if you'll give me momentarily. So Dymox or Dymox is at tab 10. And really, this is, as Mr. Manilow said, although it's a New Zealand case in legal theory, it's really the modern foundation for really all of the subsequent cases in England and Wales. And it's a classic real party case. And so just to help you with the facts, the Todds, so the defendants, were franchisees of Dymox, which was a bookseller. And there was an issue about the franchise agreement having been repudiated, and the long and short of it is that Dymox won in the Privy Council, and you get that from paragraph 2, and the Todds were bankrupted. There was a company called Associated, which was a Todd family company, but it wasn't a sort of charitable company. It was operating on fully commercial terms, and it had invested in their business. And it later funded their litigation again on fully commercial terms, including the appeal to the Privy Council. And Associated, not Todd, would have received the benefits if the appeal had been successful. And you really get that at paragraphs 3 and 4. And Associated funded the appeal in the expectation that it would yield the results to repay them and their fellow creditors. That's in paragraph 6 in the indented quote. There's an indented quotation in paragraph 6 of the relevant evidence, which explains that Associated advised that the appeal was likely to succeed, and it provided funding, and so on. And then, of course, the appeal didn't succeed. And if I can take it up at 341. Where Lord Muscle really puts it, sorry, not Lord Muscle, sorry, Lord Brown just puts it very pithily just above marginal B, associated were far from being a disinterested relative. They were pursuing their own interests under an all-monies debenture secured on strictly commercial terms. So what happens is this is a case where really they are the real party, because the Todds no longer have an interest because they've been bankrupted, and obviously therefore everything is vested in their trustee. The whole litigation is being funded and pursued for the benefit of the creditors, of which associated was the major one. And it's against that background that we have, firstly, the classic passage that Mr. Malilou has already referred to at paragraph 25, which of course is the real party. Paragraph 25, which is at page 337, where the non-party not merely funds, but substantially also controls or is to benefit, justice will ordinarily require they pay the successful party's costs. The non-party in these cases is not so much facilitating access to justice by the party funded as himself gaining access to justice for his own purposes. And can I pause there to make the submission that, in my respectful submission, even on the face of a credit hire company, particularly once you've understood the background, juristic background I've illustrated, it simply cannot be said to be the party which is getting access to justice in place of the claimant in respect of the hire claim. As I say, the genesis of the hire claim is the claimant's need to get back on the road, and it is in law and actuality always the claimant's claim. And although, as Lord Muster says, the hire company may benefit incidentally by the litigation putting the claimant in proceeds to pay for the hire car, nevertheless, you can't say that they are gaining access to justice and the claimant themselves is not. In my submission, it simply doesn't wash. It's lower down this page we get the point that there may be more than one real party, and that's obviously something that I will have to address you upon. But before I make any submissions on that, can I also show you paragraph 29, which perhaps is the passage which expresses the board's conclusion. So they say, having reviewed the authorities, generally speaking, where a non-party promotes and funds proceedings by an insolvent company solely or substantially for his own financial benefit, he should be liable for the costs if the claim or defence or appeal fails. As explained in the cases, that's not to say orders for costs were invariably made in such cases, particularly say where the non-party is himself a director or liquidator who can realistically be regarded as acting rather in the interest of the company and its shareholders and creditors rather than in his own interest. And then they say at 30, their lordships have no doubt associated would be liable. They funded the appeals. They principally, if not exclusively, stood to benefit from them. It was in their interest the appeal was brought, as was the appeal, and in their interest the appeal to the Privy Council was defended. While they didn't play much role in the litigation itself, that's not surprising because lay people don't really have much to do with appeals. That's obviously rather different from these cases which involve trials, where they might have taken instructions from the hire company, but the evidence untraversed is that they didn't. Associated here to the all-important decision to fund and thereby promote the appeal, here we have no funding. I'm going to say that the example they give of shareholders, directors and liquidators is significant because those are cases where the non-party will almost always, practically by definition, have an interest as well as the company and its creditors. By definition, a shareholder has an interest in the company profiting. A director in small companies is almost always a shareholder, but even if they're not, their security of tenure depends on the company prospering. So they will incidentally benefit from a claim by the insolvent company. But as this recognises, so long as the litigation is in the interest of the company as well, then no non-party cost order will be mandated. And that leads me to the proposition that although you may have more than one real party, for it to be the real party in place of the named party, it has to have in some aspect of the claim an exclusive interest.
So you say to be a real party, you have to have an exclusive interest in at least part of the claim.
Yes. And the explanation for the board saying you can have more than one real party here, I mean, it's of course you can. Take a claim for insured and uninsured losses. There's been your factory has burnt down. You're insured against the property damage, but you're not insured against the loss of profits. So half your claim is subrogated, and the insurer is the real party. But the other half is your claim for loss of profits, and that's your claim, and you're the real party. So there are two real parties, but in respect of both relevant interest, there is an exclusive interest of the relevant commercial entity. Because if a shared interest is enough, then as I've just said, in all the shareholder cases, there would be an exception. It would be enough to say, oh, well, it doesn't matter, it's in the interest of the company. You benefited from it as well. Because it's ex hypothesi a shareholder is going to benefit from a benefit to the company. But that isn't the law. The law makes it clear that there has to be the shareholder or the director or the liquidator have to be favouring their interests over the company's. And I'm going to say the insurance cases say precisely the same thing. And I'm also going to say it's really a concomitant of the principle of causation. So long as the named party has an interest of their own that they are entitled to pursue and will pursue in their own interests, then the fact somebody else has an interest doesn't matter because they won't have caused the litigation. The litigation is going to be pursued come what may. And Dymox, in a passage my learned friend repeatedly swerved from, because it's cited in, I think, multiple cases that he showed you, but he never showed you that passage, has actually got something to say about causation. So just to save me coming back to Dymox, that might be a convenient juncture, just to also appreciate, it might be sort of neater for your lordships and your ladyship to keep real party and causation separate, but so forgive me if I'm not presenting things in the most helpful way, but I thought rather than jumping around the authorities, when an authority deals with both real party and causation, it's best to show you the passages in one go. Mm-hmm. So causation in Dymox is dealt with, first of all, paragraph 8, which is at the foot of page 333. Causation is identified as one of the three central issues in the case. It's Roman 2 at the top of the next page. Must Dymox prove that but for associated involvement in the appeals before the Court of Appeal Council, those appeals would probably not have been brought, and is this established on the evidence? So, though as we'll see, Lord Brown deals with it pretty shortly, it was nevertheless a core issue in the appeal. And the disposition can be found at paragraphs 18 and 19.
'20, isn't it?
Oh, sorry, 18 to 20. Yes, forgive me.
Because at 20, they apply a but-for test.
They do. And can I also just say, while I'm passing this, it's not surprising perhaps that Mr. Manilu didn't show you this passage because it really is just an inconsistent, not least with his thesis that, well, what is said so clearly in Travellers can be explained with Travellers being a case about intermeddlers, not real parties, because Dymox is, I mean, it's not just a case about real parties, it is the classic case about real parties. So that point of Mr. Manilu's, in my respectful submission, is one that simply won't run, notwithstanding the fact that it seems to have convinced Mr. Justice Turner. I'll come back to that, of course.
Just give me a minute. Sorry.
Thank you. No, not at all. Yes. So my proposition is that community of interest is insufficient. One needs to have an exclusive or near exclusive interest. I've already suggested that this is clear from the specific cases concerning shareholders and directors. And I do say, is here I come to the passage from my Lord Justice Coulson in the Gochner case, which Mr. Mallory was at some pains to gloss preemptively yesterday. But in my respectful submission, the way in which he deals with it is simply not something that doesn't hold. So that's tab 26, and it's paragraph 54 of the case. I'll give you the exact page number in a moment. Yes, so it's page 646 of the bundle.
Yeah.
So what's being said here, Mr. Benson said to your lordship that even if the named party was the real party, the shareholder was the real, or director was the real party too. And you didn't accept that on the facts, but you go further. And I appreciate that because you didn't accept it on the facts, this is obiter. But your lordship goes on to say, in my view, the concept of there being two real parties, one the company and the other the relevant director or shareholder, introduces a level of complication and granularity which finds no reflection in any of the authorities. It would be well nigh impossible to apply the concept in practice, because necessarily a benefit to any small company is also a benefit to the director and or shareholder in that company. And you say it may distract the court when faced with a Section 51 application from looking at matters in the round and deciding whether director or shareholder can be properly termed the real party. Now, what Mr. Manilu said about that is that this showed there's a binary position, that was his word, binary, where you ask whose is the true interest. It's the companies, it's either the companies or the shareholders. And he said, and again, I think I quote, if it wasn't one, it was the other. So he was contending the interests are mutually exclusive. But with respect, and obviously your lordship will correct me if I'm being obtuse, that appears to be precisely the opposite of what your lordship was saying. Your lordship is saying these can't ex hypothesi be mutually exclusive interests, because the benefit of the company is always going to be a benefit, or nearly always going to be a benefit to a director or shareholder. So mutually, it's irrelevant to a non-party cost order because it isn't mutually exclusive, and in that context, therefore, what your lordship is, in my respectful submission, that is consistent with the submission I make. That in the cases about companies, shareholders, directors, of which, as your lordship knows, there are many, in that context, it has not been enough to show that a shareholder or director, who's usually a sort of alter ego of the company, derives a benefit, because they always will. What you have to show in order for them not to be protected by the corporate veil is that they are litigating in their own selfish interest. So having a shared interest in that context in my submission isn't enough. My lord, again, and my lady, again, at the risk of confusing matters by dealing compendiously with causation and real party, there is a passage on causation in this authority too, which I'll show you while I'm in it, which Mr. Manilu didn't refer you to. It's paragraph 64. Paragraph 64, page 647.
I thought that was the one we were just looking at.
No, we've just been looking at 54. I said 64.
64.
Sorry, I probably misspoke. 64, so first of page 647, there is the question of the causative relevance of the alleged bad faith or impropriety to an application pursuant to section 51. That will always be fact specific. In some cases, such as Threlfall, it was the issue that went to the heart of the litigation and so justified the making of the MPCO. But in others, bad faith or even impropriety may be of tangential relevance. I would suggest that where the bad faith or impropriety, even if established, would have had no significant effect on the incurring of costs by the applicant, it is unlikely on its own to justify a Section 51 cost order. Now, of course, I don't say your lordship there is laying down any jurisdictional prerequisite. It's clear that you're not, from your saying it's unlikely, but you are taking as a starting point that you would generally need to show but-for causation.
I think that might overstate it. Needs to show a significant effect. There was a point there about the worst they could do in relation to bad faith was to find a whole load of emails that the director had sent. And that was clearly absolutely nothing to, I think I found it wasn't bad faith anyway, but it had nothing to do with the incurring of the costs. So it was a pretty desperate type of bad faith type case. And so it was really, I cannot recall whether but for or some different test on causation was even raised.
Very well.
So I think certainly in the context of the case, I think paragraph 64 stands up, and I certainly made the point that if you're alleging bad faith or impropriety in the hope of getting an MPCO, causation is not irrelevant. You
Yes.
need to make a causative link.
Yes.
And I think that's
Yes.
what I was saying. And I certainly going that far, I completely agree with you.
Yes, and with respect, of course, there may have been a particular need to say it in the context of a bad faith case, because as I said yesterday, in fact, there are bad faith cases where there hasn't been causation because it's just expressly been imposed as a penalty, a cost order. But there's a few and far between. But I acknowledge they exist out there. But as you and that is why your lordship says it's unlikely on its own to justify a cost order. But I mean there have been. Perhaps those are more often cases about parties rather than non-parties. But where, for example, a claimant has lied about some element of their case but succeeded on other elements, they may very well just be denied the whole of their costs, even though the cost resulting from the unmasked lying might have been a relatively small part of the costs. But anyway, be that as it may, I think certainly what I show the court at 64 isn't inconsistent with my case on causation. I can at least put it that high. My lords, then can I come to Travellers, which deals, of course, both with the identity of the real party, identifying the real party, and with causation. I'll deal with real party first. So Travellers, it's tab 24. Now, this is another context, as with shareholders and directors, where I take as my starting point that, by definition or ex hypothesi, if an insurer is involved in the case, the insurer will have an interest of its own. Obviously, insurers don't get involved in cases unless they have an interest in being involved in them because they're on the hook contractually. So there is no question that in any case where a liability insurer is active in defending it, or a subrogated insurer is active in pursuing it, is that interest will have its own interest in the litigation. But Travellers makes clear in the context of insurance that the fact the insurer has an interest is not enough to render the insurer a real party. And that's the case even where, as in Travellers, the insurer is conducting defences through solicitors it appointed and paid for, making all the decisions in the case, including the settlement decisions, and had the principal commercial interest in defending the case in that it would pay the judgments, if there had been any, and indeed there were some. But none of that was sufficient, the Supreme Court holds, discharging the cost order made by the trial judge and affirmed by this court, because at all times the insurer was acting in the interest of its insureds as well as itself. There's no suggestion that the mere fact the insurer is acting in its own interest as well as its insureds is sufficient. And if I can just show you, it is as clear as it can be from Lord Briggs's analysis that the distinctive feature in order to endow a cost order against an insurer on real party grounds is that the insurer has departed from the interests of its insured and instead is acting in its own sole interest. And Lord Mustall, I'm so sorry, I keep calling everyone Lord Mustall. Lord Briggs shows that with an exposition of 5 previous cases, many of them decided by this court. If I can take it up at paragraph 38. Well, in fact, perhaps I should show you paragraph 35. They introduce, his lordship introduces the Chapman case, and then discusses it over the successive paragraphs. And I was going to take up the discussion of Chapman at 38, page 526. The claimant company relied upon 5 features of the case which justified a Section 51 order. And those features are all, the fourth of those features is the insurers fought the claim exclusively to defend their own interest. And then his lordship says, the Court of Appeal agreed, much the most important consideration for both purposes was that the claim had been funded and defended by the insurers purely in their own interests, regardless of the interests of the assured defendant, who had been entirely without means from start to finish and would have been content to settle the case at the outset rather than contest it. The insurers were regarded as the real defendants in all but name. Now, obviously, I recognise that my case also involves claimants of limited means, although I don't think we go so far as to say they're entirely without means. I don't doubt that the district nurse, Mrs. Smith, would have been able to pay off the hard charges ultimately in instalments. But you can't, however, for the reasons I've already given, you can't say, in my respectful submission, that this hire company is in anything like the position of the insurer in Chapman, because it's not controlling the litigation at all. It's not funding it. It's got no power to settle the case. And it certainly can't be said that the case was being exclusively pursued in its interest, even the higher element. And then, as I say, there are 5 cases. I'll take them very quickly. Paragraph 39, his lordship...
I always thought that one of the critical points in Chapman, as is summarised in paragraph 38 of Lord Briggs's judgment, is that the claimants would have been content to settle, and effectively the case fought, because that's what the insurers wanted.
Yes.
Not the claimant.
Yes. Yes, I don't disagree with that. We do have Chapman in the bundle. If at some point
well, I'm sure this is. I'm entirely happy to
I wasn't proposing
accept this.
Yeah.
But that it was a particular
feature.
Yeah.
And then, my lord, 39. There's a citation of Mr. Justice Thomas in a case called Citibank, and I'm just going to take about 3 or 4 lines down. Mr. Justice it's decided by Mr. Justice Thomas specifically upon the basis that the continued defence of the quantum of the claim after judgment on liability had been conducted by the insurers solely in their own interests. That's another exclusive interest case.
We don't have that.
No. I think we took the view that the authority bundle was too long, so we didn't. So if there are any cases, of course, it would help us to file. We can.
No, that's fine. I think I was in that case.
Oh, right.
It's ringing a vague bell. They wanted, because I was for the insurers, they wanted a complete MPCO, and we fought it off for most of it, but the evidence was overwhelming that when it came to quantum, that was entirely the insurer's decision to carry on.
Right. And then paragraph 40, yes, and in fact, at the end of paragraph 40, the insurers, I know I don't need to perhaps read that.
They're entirely motivated by their own interests.
41, they start a case called Cormac. Now, Cormac is, the first point I asked the court to notice about Cormac is that it is itself, quite explicitly a real party case. And the reason that's important, you'll see later, because Lord Briggs founds his discussion of causation on Cormac. So again, with the greatest respect to Mr. Madeleine, and it's my submission, it's quite hopeless, this contention that what Lord Briggs says about causation is confined to intermeddling cases, because he talks about Cormac, and Cormac is a real defendant case. But by marginal D, Cormac a cost order was made in Cormac because marginal D, the judge decided the insurers had not conducted the litigation. I'm so sorry. The reason the non-party cost order was refused in that case was because the judge decided that the insurers had not conducted the litigation solely in their own interests. Obviously, no dispute that they had an interest. And the defendants had throughout an interest in defending its reputation. Further, the insurer's conduct of the case had not been the cause of the claimant incurring costs in excess of the limit of cover. So there's some but-for causation as well. And at 43, by marginal G, you'll see there's a reference also to this court in Cormac, again, firmly endorsing the need for the applicant, that's the applicant for the costs order, to demonstrate that the relevant conduct of the insurer or some part of it caused the claimant to incur the costs sought to be recovered under section 51. And then we have Palmer and Palmer at paragraph 44. In that case, a non-party cost order is made, the judge concludes the insurer's conduct of an unsuccessful defence was sufficiently self-motivated to make it the real defendant in all but name, the Court of Appeal dismisses the appeal. And then lastly, at the top of the next page, we have a case called Legg. And picking it up on the right-hand side of the page, just above marginal C, the judge held and the Court of Appeal agreed that the insurers had defended the claim solely or predominantly in their own interests because they were concerned not to defend the insured from more liability, but only from liability for the head of claim covered by the policy, and the insured had no commercial or reputational reason to defend the claim. So those are 5 cases where the fact the insurer has got a major commercial interest is not in any sense dispositive. What tips the scale one way or the other is the question as to whether its interest is exclusive. And then I'm going to come on to what Lord Reid has to say about the real party test as well, which Mr. Manilow didn't show you. But just before I do, because Lord Reid is giving a concurring judgment, and as will be seen, and in the finest tradition of the Scottish law lords, he demonstrates that the Scots got these things right long before the English and Welsh did. He refers to Scottish authorities. I just ask you to know that at paragraph 53, Lord Briggs accepts that the Scottish parallels are helpful and appropriate. So in essence, that's adopted by Lord Briggs, giving the judgment which the other lords all concur in. And so jumping to Lord Reid, is page 540, if I can invite the court there. And it's really between paragraphs 95 and 98 that Lord Reid draws this parallel with the Scottish concept of the dominus litis, or litis, I should say, dominus litis, the master of the litigation. Can I invite the court just to cast an eye over paragraphs 95 through 98, please? So I obviously don't
take it that civilian terminology is not synonymous with everyday speech.
No, I think that one can derive that. But it'd be that, I mean, obviously, I don't go so far as to say that we precisely assimilate the position in England and Wales to the way it's put by the Scottish judges, and to do so also would perhaps fall into the trap that your lordship identified in the shareholder case about treating things as dogmatic principles rather than indicia. But nevertheless, I do say that what is identified here as the typical characteristics of a dominus litis, or a real party, is something which goes far beyond the role played by the hire companies in this litigation. People who control it, who have, and people who have the sole interest in it. And I do say that this passage is consistent with my proposition that you are the real party if you have it's not sufficient that you have a benefit, as put expressly at 98. Not sufficient that the party has some ultimate consequent benefit, as my client does. He must have a direct interest in the subject matter, which must be the true interest, the entire interest, the whole interest for all practical purposes. and I do just say that that, as Giles and Thompson shows, simply cannot be said of the credit hire company. And for completeness on real party, can I lastly just, I'm afraid we are going to go back through back through this case again to look at causation quickly, but just show the very short, perhaps even terse, concurring judgment by Lord Sumption at page 545. Lord Sumption just makes the point again that commercial interest is necessary but not sufficient. He says the common law has an instinctive reluctance to make orders in private law litigation which affect non-parties, but also have a long-standing aversion to the unjustified interference by non-parties in other people's litigation. The first of these instincts is founded on elementary principles of justice. Non-parties may well have a more or less direct commercial interest in the outcome, but they do not thereby assume the risks, by which I assume he includes the cost risks, associated with contested litigation. And then he gives the example of real parties being, for example, an assignee or a subrogated insurer. And that's one of the reasons why the court will perhaps now see why I laboured Giles slightly in that it determines that credit hire companies are neither of those things and nothing like those things.
Well, might it not be said that a credit hire company precisely is a company which assumes the risk associated with contested litigation? Because what the company does is takes on a financial, lends, obviously hires the car to the individual, and is only going to get paid if the litigation succeeds.
Yes,
isn't that exactly assuming the risk associated with contested litigation?
Bearing in mind that this is a discussion that's taking place in the context of the question to be determined as whether or not a non-party should be subject to a cost order. In my respectful submission, what Lord Sumption is talking about there, and he's talking about the common law's instinctive reluctance to make orders against non-parties, then he is talking about, well, just because you've got a commercial interest in the outcome of litigation, you don't assume the risks associated with it. That's the cost risk in context. Because obviously the whole premise is that they do have a direct commercial interest in the outcome of the litigation. I accept that's the hire company, but he says that's not sufficient.
So you say the risks it's talking about are the cost risks?
Yes, because that's the context of the case. I mean, that's my proposition. Okay. So that's Travellers on real party. I appreciate it's talking about insurers, but after all, the defendants have picked up the taxonomy of this case. They initially said the hire companies are both real parties and intermeddlers. They've now dropped into meddlers, but they still say we're real parties. And if they want to propose that the question of who's a real party is treated less rigorously in the context of hire companies than it is in the context of insurance companies, who ironically, of course, these two entities are on the same side of this litigation. Hire companies one side, liability insurers on the other. The liability insurers somehow get a more favourable treatment about whether they're real parties than their counterparty. And equally different from the treatment of who's a real party in a corporate context, then I respectfully say Mr. Manilow really has to identify some cogent reason why the law should be inconsistent in that way, and he certainly hasn't so far. Can I come back then to much more quickly to what this case says about causation, because Mr. Manilow has shown you what Lord Briggs says, but with great respect to him, he did rather muddle what Lord Reid said. But going back to what Lord Briggs says and the proposition that it's all about intermeddlers, that's page 532, paragraph 65. As I say, it may be that I'm going to end up labouring this point because I shouldn't need to say anything more. Since the learned Supreme Court Justice opens this with adverting back to how firmly the Court of Appeal in the Cormac case endorsed the requirement for an applicant under Section 1 to demonstrate a causative link between the incurring of the costs sought to be recovered and some part of the conduct of the non-party alleged to attract the jurisdiction. This requirement is, in my view, rightly imposed. Well, since Cormac, as I've very recently shown you, is itself a real party case, to suggest this is only about intermeddlers, in my submission, it's a horse that simply doesn't run. And even if it might run in the structure of the judgment, which it clearly doesn't, but if the structure of the judgment might at least permit the horse to run, when you come to this very pithy rhetorical question that ends the paragraph, if the cost would still have been incurred if the non-party had not conducted itself in the relevant manner, why should it be just to visit the non-party with liability for them? Mr. Malalu has identified no reason why the answer to the rhetorical question would be different in the context of a real party rather than in intermeddler. And the reason he hasn't identified a reason for it is because there is no sensible reason why the treatment should be different.
Sorry, which paragraph is that rhetorical question?
It's the end of the same paragraph, my lord, last 3 lines of paragraph 65.
Yeah.
And can I also say that also Mr. Malalu, I think didn't show you that Lord Briggs comes back to causation at the end of his judgment, and that's a paragraph that begins at paragraph 76, so page 535. So this is in the context of drawing together the threads of this rather long analysis into some concluding propositions, and then you'll see he immediately talks about both real defendant and intermeddling. And then he gives the various principles he extracts. And the fifth of those principles is causation, and it's foot of the page, paragraph 80. Causation remains an important element in what an applicant under section 51 has to prove, namely a causative link between the particular conduct of the non-party relied on and the incurring by the claimant of the costs sought to be recovered. If all those costs would have been incurred in any event, it's unlikely that a section 51 cost order ought to be made. That is again a completely unqualified general statement as part of a summary that is referring both to intermeddling and to real party cases. My lord, as to Lord Reed, page 538, paragraph 90. The court Mr. Malalu showed the court this passage, but he failed to refer to the words that he said he'd refer to. So an example of a award against a real party is in Reed Jones. So this is an English case. That's where the solicitor engaged to indemnify the plaintiff and he's ordered to pay the costs. And he quotes Lord Hatherley. But the key words of Lord Hatherley that Mr. Malalu omitted are the ones in the indented quotation, where a solicitor takes upon himself the conduct of the suit by saying that he will indemnify his client against all costs, where the plaintiff is a mere puppet and the real party suing is the solicitor. The court will hold the solicitor liable for all the expenses to which he has put the other parties by his conduct. That is the Lord Chancellor's dictum referred to in the Indian case immediately below. But Mr. Malalu read you the reference in the Indian case to the Lord Chancellor's dictum, but he didn't show you what the dictum was. It's that dictum. You're liable for the expenses to which you've put the other party. That also is a test of causation. And may I also say here too, you see an approach in an English case to something very similar.
We're getting slightly onto the end of a pin, aren't we? I mean, all the Lord Chancellor there is saying is that if the nominal plaintiff is a puppet and the solicitor has run everything, then the costs which have been incurred by the other side will have been incurred as a result of that solicitor's conduct, and he has to pay. It's not rootling about in different causation tests. It's just saying he's liable for all the expenses to which the other party's been put by his conduct. His conduct being running the case in a case where the claimant is the plaintiff is the puppet.
But Lord Reed goes on to comment as a marginal H. It is noteworthy the Lord Chancellor.
Attention, please. This is a security control office. You are now invited to observe a 2-minute silence to mark the 80th anniversary of VE Day.
We will observe that.
Thank you.
Yes. The comment at H.
Yes, forgive me.
Yes.
Never.
So the need for a causal connection.
The need for a causal connection. But also Lord Reid returns to the issue explicitly himself at paragraph 99. That's at the top of page 541. This is the alleged. This is back to the discussion of dominus litis.
Oh, yeah.
The alleged dominus litis must also, of course, have caused the expense for which he is sought to be made liable, and he quotes the Lord Precedent. And I just pause for the court to read that quotation. So we do say that causation is front and centre in the cases. It's impossible for Mr. Malalou to contend, as he does, that what is said here can just be localised to intermeddling. And even if it was possible to say it, it doesn't actually make any sense conceptually. And also, with respect, Mr. Justice Turner is therefore wrong on having seized on that as a point of distinction of travellers in the Kinderton's case, which Mr. Malalou took you yesterday. I'm not going to ask you to turn up the Kinderton's case again, but it's paragraph 56. I'm told that, in fact, having just seen the language of Puppet Master, that although Mr. Malalou isn't on the cast list for that case, it was actually his skeleton argument. So Mr. Malalou, powers of advocacy were such that he persuaded Mr. Justice Turner from afar. But it's my regretful submission that by doing so he thereby led the learned judge into error. My lord to my lady, again, I'm obviously conscious that the time is narrowing. Can I just make a few additional points on this issue for your lordship, your ladyship's note?
Which causation?
Causation,
Yeah.
yes. So first, in our skeleton in DAMS, paragraph 21b, refers to a pithy statement by this court about a general need for causation in a case called system care, which I know my Lord Justice Coulson is familiar with. The bundle reference for system care and the relevant quotation in our skeleton, although it is fully quoted in our skeleton, it's tab 17, page 414, paragraph 23. And system care, of course, is a real defendant case. It's a corporate, it's an alter ego director who is found to have given dishonest evidence and such like. So I'm just pausing because I think my lord is looking at the passage. So
And just remind myself, it's Mr.
Mr.
Justice Lewison as he
judge
then
of this
was.
court.
Yeah.
Yes. Then, my lord, my lady, in our Spectra skeleton, paragraph 59, we make a point that a test for causation is applied in what, on any view, is a closely related cost jurisdiction, which is the wasted cost jurisdiction. And we cite at paragraph 59 Lord Bingham in a well-known case called Rydhall and Horsefield. And I was just going to give you the references to the relevant passages in the cases we cite. So Rydhall is, I managed not to have the tab number written down, forgive me. Rydhall is tab 4 of the authorities. And it's using the bundle page numbering, is Lord Bingham at page 138 at F and 144 also at F. So 138F and 144F. 144F, he says that in a wasted cost context, demonstration of a causal link is essential. And there's some discussion, as we again say in the same passage of our skeleton, there's some discussion in a case of Mr. Justice Neuberger as to whether or not that's but for causation, and he says that it is. And that case is a case called Brown, and the bundle reference for the relevant passage is tab 7, page 225. Paragraphs 51 to 54. And those are marked up with sidelines. My lords, my ladies, my learned friend really, his thesis about intermeddling aside, he cites the total spares case against me. I'm not going to turn up that case again because in my respectful submission, it's just impossible to see how it helps my learned friend, because all total spare says is, well, causation may not be jurisdictionally prerequisite, but Mr. Justice David Richards says that it will often be the vital factor. And as my learned friend points out, and so I won't take you back to it, in Turville and Bird, as Lord Justice Hamblin points out, there actually was causation in total spares, albeit causation of a slightly different kind, because as a result of the non-party's misconduct in asset stripping, the defendant was caused a loss in terms of costs which he would not otherwise have suffered. And that was also the position in Turville, because the non-party had been instrumental, amongst other things, to the confiscation of an insurance payment that would otherwise have been available to pay the applicant's costs. He found that there was causation in that case as well. Now that, of course, is not causation of the cost being incurred, but it is still in both cases the non-party cost order is made because the non-party has caused the defendant to suffer a loss. And that is what Mr. Madalou's clients failed to show in both the cases below. They were unable to identify any costs that would not have been incurred anyway because of the personal injury claim, for example. And as you know, without repeating, because I really made the point yesterday, but it's here I'll come to the practice direction. We say it's fatal for the freestanding reason also, which is that Parliament, having determined that in return for the many benefits of the Jackson reforms, defendants in personal injuries cases will bear their own costs, then they really do need to show that they have been caused some cost above and beyond the cost of the personal injury claim which they have to bear before they have a remedy against a non-party. Now, of course, you can well imagine, obviously, there may well be other points to make, but there may be credit hire cases where a personal injury claim is settled very early, and a case goes all the way to a sort of 2 or 3 day trial before a circuit judge, where all these points about misrepresentations and such like are taken, and it ends in disaster. Now, there may well be there would be other objections to there being a non-party cost order in that case, but there wouldn't be a causation objection, because there would be, you'd be able to show that there were costs attributable to the hire claim which were more than de minimis and exceeded those that caused by the PI claim. But that's neither of these two cases, and I have to say I've yet to encounter any of these cases where a defendant has been able to show anything more than de minimis additional costs.
De minimis additional costs caused by
on the hypothesis the hire company has become the real party, which of course I dispute. Yeah. On the hypothesis it has participated as the real party to the credit hire claim that's been caused by its participation, or caused by the hire claim. Now, so far as that's, because this is a convenient time to visit the practice direction, which is at tab 4 of the statutory part of the bundle, or the rules and practice direction part of the bundle. I mean, from my perspective, the practice direction is a curate's egg in the true sense of that term, in that it's good but only in parts. I obviously acknowledge that at paragraph 12.2, credit hire along with subrogated claims is given as an example of a case made for the benefit of a third party. I simply say that's a wrong statement of law for the reasons I've previously given you. Can I just
ask you about that?
Yeah.
That submission depends on the point that the rule, which he uses the expression for the financial benefit of a non-party, the financial benefit of a person other than a party, doesn't change the existing law.
Yes.
That came into force. Well, is that right?
Well, of course, it goes further. It's not even a rule; it's a practice direction.
No. The expression "financial benefit of a person other than the claimant" is a quote from
yes.
the rule.
Oh yes, but the rule doesn't say and a credit hire company is.
No, but the
Yeah.
rule uses the term financial benefit of a person other than the claimant.
Yes.
Now, as I understand, you say that this statement at 12.2 is wrong in law because you're saying that the rule, which this is the terminology of the rule doesn't change the existing law about non-party cost orders.
Well, that and as is common ground between Mr. Malulu and myself,
Yes.
because that's what Mr. Justice Turner decides, and Mr. Malulu says that's right.
Is it right?
Yes,
Okay.
in my submission. And as to the the practice direction itself, your lordship is of course absolutely right to say the way in which practice directions are made has been changed since you and Liverpool was decided. But the proposition of practice direction can't change the substantive law. I would be bold enough to say, even if it weren't for authority, that would seem a self-evident proposition. But the U case, which for the notes is tab 11. Page 351, the relevant paragraph being paragraph 48. That is a case which has been, the principle in that case has been restated by the Supreme Court as recently as 2018. That practice directors can't change the law.
Which case was that?
That's a case we don't have in the bundle called an anonymous NHS trust versus Y. We can obviously submit that case if it would assist the court. But I don't believe that Mr. Malulu disputes that a practice direction can't change the substantive law. But if it would help the court, we'll send that in. So that's the negative part of the curate's egg from my perspective.
So you let's just get this clear. You say that 12.2 is wrong in law.
Well, I'm simply saying it's a misstatement. It miscategorises credit hire claims because they're not bought for the benefit of the third party. They're bought for the benefit of the claimant on the authority of Giles, Thompson, Diamond.
Well, they may be. I mean, it may, assuming your submissions are right about Giles and Thompson
Yes.
and so on, you could still have a situation on the facts where a credit hire claim is for the benefit of somebody other than the claimant or defendant.
You could,
And so I quite understand your submissions. That's not this case. Completely understand that.
Yeah.
But I'm just looking at the wording of 12.2, and it says examples of claims are A and B.
yes.
So A and B are situations where there could be, it might be found that the claim was brought other than for the benefit of the claimant or the defendant.
It may be that my objection is more to the unqualified and general nature of the proposition.
Well, I was going to say, it may be loose language in the PD examples of claims.
Yes, and it is a PD, so...
I understand that, but I'm just, I think that examples of claims which may have been made
Yes.
for would be right.
I mean, it may be that I'm adopting a sort of overly dogmatic view.
Well, I don't think anybody is saying that the mere fact that it's a credit hire claim means it's a claim other than for the benefit of the person. Otherwise, this appeal would have been listed for an hour, not 1.5 days.
Yes, well, as I say, it may be that I'm sort of confronting an enemy I don't need to confront.
Anyway, I understand your submissions. So that's you like that bit. Sorry, you don't
that's
like
the
that
rotten
bit.
part of the curate's egg, if I can put it that way. The savoury part of the curate's egg is, of course, I say of course, because I know the court knows I'm going to say this, is the word attributable. And that actually occurs in more than one context here. So at 12.4, the practice direction is addressing a different exception to Quox, which is fundamentally dishonest claims. And you'll see that at D, the top of page 52, the court may, as it thinks fair and just, determine the costs attributable to the claim having been found to be fundamentally dishonest. Now, I do say that seems, in my submission, to be a fairly clear indication that there will be at least some sort of causative inquiry. And I just said that's inherent in the word attributable. And to some extent, my Lord Justice Coulson presaged this with me yesterday. So I've anticipated, I may have already said this, but where it refers to as it thinks fair and just, that in my respectful submission, that doesn't mean that this is a sort of palm tree justice here. But what it does mean is that the process which the court has to adopt for determining the cost attributable is a process in which the court has a leeway to do what's fair and just, because of course in many of these cases the sums of money we're talking about really are very small. This is not litigation in the High Court. It is, as I say, the costs in the costs order in the Spectra case is about £3,500. So of course in those cases a judge isn't expected to conduct a sort of detailed assessment as to what, if anything, is attributable to the higher claim. They can paint with a broad brush, but the ultimate exercise is to identify that which is attributable. And I say again, you have attributable again specifically in the context of third-party claims at 12.5. And 12.5b, you have the same formulation.
Well, Mr. Williams, isn't 12.5a more difficult for you? Because if it applies, and I understand you say it doesn't, I get that completely, but it does indeed say cost attributable, but that's after the word or, and the bit before it is, by contrast, pay all the costs,
well,
which,
yes.
And if you read it, as it were, in your sense, and I'm not saying it's wrong by putting it that way,
I understand.
label it, to pay all the costs or the cost attributable. So if the attributable is your causation test, this is a clear indication that you could be ordered to pay all the costs, not with the causation test.
Of course I see that linguistically, but I said the only explanation of that, because it can't, we respectfully submit, the intention of the practice direction can't be to leave to the court a sort of unfettered discretion as to whether or not to adopt a causation test. I would suggest that the reference to all or the cost attributable is a recognition that some cases will be wholly for the benefit of a third party. Classic example of an insurer recouping its outlay through a right of subrogation. Or obviously that huge amount of litigation, particularly in the county court, is the sole head of claim will be a subrogated claim by an insurer that's paid out. And in those cases, all of the costs would be the costs. But in other cases, there'd be a mixed claim. There might be, as my example of the factory that burns down, and there's a subrogated claim and an uninsured claim. In that sort of case, there'll be an apportionment. And then that does lead on to D, which is qualified in any way. The court may, as it thinks fair and just, determine the cost attributable to the claim having been found to be fundamentally dishonest. So, of course, I entirely take your lordship's point, but as I respectfully suggest, the way I've explained it is an explanation which holds together. Whereas the quite natural way in which the lordship put matters to me, actually, when you think about it, would be too arbitrary a way of reading the practice direction. Can I then, again, because I'm nearing the end of my allotted time, and I've still got quite a few things to cover, just elusively to my skeleton, we take an extra point here, which is that it's the Spectra skeleton at paragraph 60. We also point out that courts are adopting a causation approach in another related context, which is, and it's what I know, certainly my Lord Justice Coulson has sat on a case involving the so-called mixed claim. That's the claim where there is a personal injury element and a non-personal injury element. And an absolute classic one, for example, is a claim against the police, where you're alleging that you were wrongly arrested, false imprisonment, and they also injured you. And obviously that has a PI and a non-PI element, and that's become known in the jargon of the shorthand as a mixed claim. Now, in those cases also, quox can be disapplied for the non-personal injury element. But the approach which at least the courts at first instance have been taking to that is an inquisition into what are the additional costs which have been caused by the non-PI claim. And in our skeleton we cite as an example Mrs. Justice Hill in a case called ABC and Derbyshire. So that again is at paragraph 60 of the Spectra skeleton. And can I again please just give the court a reference for the passage? Paragraph
50 or 60.
Well remembered, my lord. I think in my note it's 63 to 65. Paragraph 60. Oh, sorry. Paragraph 60 of the Spectra skeleton. Forgive me. I was yeah. Paragraph 60 of the Spectra skeleton, and the relevant case we cite. That's at tab 27, page 665. So 27 tab, page 665, and it's paragraph 63 to 65 of the authority. And what happened in that case is Mrs. Justice Hill. There was a case where she was considering allegations of false imprisonment and personal injury against a council which was alleged wrongly to have removed children from their parents. The claim failed. She held that 95% of the costs were the cost of the personal injury claim and awarded the council 5% of its costs as outside quotes. And we do say that if a causation test is being applied in this, I mean, unless this court says a causation test is wrong, but on the assumption the court doesn't say that judges like Mrs. Justice Hill are approaching this question wrongly, because it certainly seems to, in our submission, conform with common sense. If you're applying but-for causation in these closely related areas like disapplying quotes in mixed cases, why on earth would you take a different view in the context of disapplying costs because a claim has quotes because a claim has a third-party element? I've promised Mr. Malilou 15 minutes for reply, so I've got about 20 minutes left. I must use that to deal with the case of Farrell, which my learned friend puts a great deal of emphasis on. Because I'm very unfortunate with Farrell in that I can freely say, well, the case looks as if it was badly argued for the reason Mr. Malilou explained yesterday. It was me, albeit when my hair was less grey. I do say with respect that...
So this is tab, remind us?
15.
Thank you, my lady.
Thank you very much.
Yes. So it begins at page 388. Mr. Malilou puts a great deal of weight on this. I hope it isn't thought a cheap point if I say it's an objective sign of him rather overstating its importance. It's firstly, as I said yesterday, that 6 years passed after Farrell before another non-party cost order is recorded against a hire company. And we're here 16 years later really arguing about the point that Mr. Malilou is asserting has already been decided in Farrell. These do tend to be indicators that perhaps this extemporary judgment is having a little bit too much weight put on it. Now, so far as that's concerned, the first point I make is it concerns a different hire agreement, and this is a hire agreement which contains a contractual, a quasi-subrogation contractual right, and that's at paragraph 2 in the indented quotation. I think Mr. Malilou showed you this. The lessor shall have the right to pursue an action in the hirer's name. The lessor shall have the right to pursue an action through the county court and the high court, and the hirer must cooperate. So the hire agreement goes much further than the hire agreement in both these cases. There is also the point about funding, which doesn't apply to either of these cases. Paragraph 4, which again Mr. Malilou, I think, referred to. There are two collective agreements, collective conditional fee agreements between the solicitor, which DAMS is actually a party to. It's described in the agreements as the funder. It states that DAMS has been appointed to manage and process their claims, and DAMS is jointly and severally liable for the costs and disbursements of the solicitor. So that is another point of distinction. The other point is that the case was decided on inadequate evidence. Decided against DAMS because DAMS's evidence was inadequate. That's a criticism of my client. It's not a criticism of the court, I hasten to add. I didn't appear at first instance, so I'm just getting this from the judgment. But paragraph 7, at the end of paragraph 7, it's recorded there's a witness statement from Mr. Bailey, but he's an administrator, not a manager, and he referred to correspondence, but he didn't produce it. And then at paragraph 8, it records how the trial judge found Mr. Bailey to be a committed advocate for DAMS and a reading between the lines, an unconvincing witness. And so the judge makes findings of fact that DAMS was the instigator and the controller of the litigation, as well as merely deriving a commercial benefit from it. And as a result of those factual findings resulting from DAMS's inadequate evidence, which weren't impeached on appeal, you'll see at paragraph 9, DAMS conceded by the appellate stage the very thing which I challenge on different evidence with a different agreement. That the judge's conclusion, DAMS accepts the judge's conclusion there was a sufficient nexus between the claimants and DAMS to render the latter amenable to a third-party cost order. So DAMS accepted that. So DAMS did not challenge that the real party test was satisfied, and as you can see from the next sentence, the appeal was purely against the judge's exercise of discretion. DAMS contends the judge failed properly or at all to exercise his discretion. That's a mark of an extemporary judgment, because they obviously didn't contend he was wrong to exercise his discretion. He didn't exercise his discretion at all, because he did. He exercised it by making a cost order against DAMS. but they allege that he shouldn't have done that. So that's the allegation, and perhaps unsurprisingly, given the infertile ground for appeals against exercises of discretion, that appeal failed. But in my submission, it fails for reasons which are case specific and don't have analogues in this case, and which therefore don't assist Mr. Mallory. So we see at paragraph 14. Firstly, it's the terms of clause 5 of the hire agreement. Those terms are now DAMS does not have the rights it used to have. The judge's factual finding unimpeached that DAMS was the instigator of the litigation. Well, there aren't factual findings like that in these cases, and we say there couldn't be. Secondly, the claim is prosecuted by solicitors in the names of Farrell and Short. Well, that is not the situation here. These aren't simply cases pursued in people's names. There's no finding to that effect. Then they say, although the CFAs came later, it's not suggested they didn't reflect the actual position, and so they showed the intimacy, if I can call it that, between DAMS and the solicitor, the then solicitor. They provided that DAMS had been appointed to manage the claims. Absent evidence of the contrary from DAMS, a natural inference is that the proceedings were pursued and later discontinued with the knowledge and approval of DAMS. Well, that's in the DAMS case here. The evidence from Mrs. Levins is unchallenged and accepted by the judges that DAMS wasn't involved in the litigation in any way. So that finding couldn't be made here. And in Spectra, the pursuit and discontinuance of the claim, the positive findings that Spectra had almost no involvement in the pursuit and no involvement whatsoever with the discontinuance. The only point at which Spectra was found to have been involved in the pursuit of the claim was when the claimant's solicitors wrote to them to ask them to do a particular task, and they did that task. That was the full extent of it, and those are unchallenged factual findings. And then when it comes to funding, DAMS isn't funding in this case. It was the funder under the CFA. Mr. Malalu puts a great deal of emphasis on, they say they funded the case in the sense that they funded the hire car. But I do say, with respect, and this is no doubt an artefact of inadequacy of argument on my part when I was rather more junior, is that just misses the essential point that in these cases the real instigation and the real catalyst is the need for the vehicle. And can I also say that when Mr. Manu says there's no finding of causation in this case, in my respectful submission, he's wrong about that. The reference to the hire being the essential catalyst is I appreciate it may be compressed, but on the face of it, that's a saying there's causation. You know, that's what a catalyst does. It causes something to happen which wouldn't otherwise occur. But if I'm wrong about that, then again, no doubt through insufficiency of argument on my part, the court has simply not given causation the attention which a host of subsequent authorities demonstrate it should have had. And I've already addressed you on those authorities. So I do say with respect that the DAMS case, the Farrell case, really doesn't help my friend in the way that he contends for. They also, and they say I accepted it, which I think with respect can't possibly be right, because the principle in Hodgson was very well known that the fact they couldn't have got, that they didn't seek costs from the solicitors was irrelevant because they could have done. And in fact, they couldn't have done because the court of, all the authorities of the Court of Appeal say they couldn't. So again, it's an extemporary judgment, and it perhaps wasn't the main point in the case. My Lord, there are then, and my Lady, there are some other first instance cases my learned friend refers to, which I'm going to deal very briefly with and elusively to our skeleton because it addresses them in some detail. The two decisions of Mr. Justice Turner, the first being me or select rent-a-cars, tab 23. As I said, it's common ground between Mr. Malalu and myself that Mr. Justice Turner is right to say that the Quox rules don't enlarge the jurisdiction for non-party costs. I also invite the court to note that Mr. Justice Turner actually accepts that financial benefit of itself is insufficient. It may be necessary but not sufficient. That's his judgment of paragraph 38. But so far as the outcome is concerned, firstly, Mr. Justice Turner isn't determining any point of principle. He's merely holding a recorder came to a conclusion which was open to him as a matter of discretion. And he quotes the recorder's reasoning at paragraph 24 of his judgment. we say there are multiple points of distinction, and we identify them in our skeleton. As my lord said to me yesterday, I'm not going to be thanked for repeating my skeleton, so I won't. Just at a high level, the hire company had much wider rights to control the claims, and it also, and this might be important, had a right to appropriate the damages, even damages for the non-hire elements. So it could dip into the personal injury damages, for example, and pay itself out of those. And those have no equivalent in this case. And my lord, my lady, this reference to our skeleton, this is the DAML skeleton, it's paragraph 29.
So just in case I've missed it, Mr. Williams, as I understand it, I'm not trying to put words in your mouth, you're not submitting that Mr. Justice Turner's decision in me select was wrong.
I don't need to set up that obstacle for myself. I mean, I wouldn't like.
Sound like you.
Yeah. Well, I mean, for example, causation isn't considered at all, and that's not Mr. Justice Turner's error. I assume the point wasn't taken. Whether or not if causation had been taken, there would have been an issue. I can't say precisely because the judgment doesn't explore it. But I would, as the last point I was going to make, is that causation is not mentioned in this case, which of course predates Lord Briggs's search for principle in Travellers.
So what was the answer to the question other than the qualification that causation wasn't addressed?
Well, the answer to the question is that a series of reasons are given at paragraph 24, which I can't say, I won't go so far as to say didn't provide a route to a non-party cost order. It's just hard to say when I've just got the judgment. I certainly don't say it's obviously wrong, subject to causation not being considered, because there were just key points of distinction. For example, the hire company in that case actually instructed the solicitors. No, I don't mean in the sense they nominated them. They were their clients and were giving them instructions. So it really is a much more...
The reason it's probably obvious, but I just want to make it absolutely clear. The reason I'm pressing you a little on that is that we have been invited, I think, by both sides, certainly by one party in this case, to give general guidance.
Yes.
And so, at least bluntly, it matters to me, it's not meant to be a pun, by the way, it matters to me whether me is you're saying me is wrong. I think you're not, but that's fine. I genuinely don't care, if you see what I mean. It's your case.
Well, but I mean, the reason I'm sitting on the fence about it isn't out of a sort of coyness. It's simply because I only have the prism of the facts which Mr. Justice Turner relied on in saying the recorder came to a decision within his discretion, and certainly those facts could begin to suggest that the hire company took an unusually active role in the litigation, in that it instructed solicitors, it gave itself a right to appropriate damages. But my basic proposition is that these claims are always and everywhere claims in which the claimants have an interest, and therefore, barring some exceptional feature, the interest of the claimant means that there can't be a non-party cost order, because for there to be a real party, you have to have an exclusive interest. And it's certainly not clear to me on the face of the authority that the hire company, albeit it was much more deeply involved in the litigation than the hire companies here, it's not clear to me that it did have such an interest. So it may well be that on an application of my hypothesis, I would say that case was wrong. But obviously, Mr. Justice Turner heard the argument that he did. As I say, causation is not even mentioned, which does tend to suggest it wasn't the fullest of arguments. Now, I really, will the court forgive me if I slightly canter in my last 10 minutes. The Kinderton's case, tab 24, that's addressed in detail again in our skeleton in DAMS at paragraph 31. And I respectfully adopt that. I don't suppose I need to be respectful when adopting my own verbiage. Again, just to compress it, really the hire company promoted a claim that on the judge's findings should never have been made. It controlled it under two agreements far more onerous than those in this case, which essentially created contractual rights of subrogation. Under the second of those agreements, Kinderton's had to agree to any settlement. And that led to a positive finding of a high degree of control, which couldn't be made in these cases. And Mr. Justice Turner's treatment of causation, for the reasons I've already given, is wrong in law. And I do say, therefore, that that case is wrong because of the mistake about causation. Whether it's wrong about real party, given the undisturbed finding of the recorder, there was a high degree of control, I simply, it may or may not be. But I would say control absent the hire company having the exclusive benefit would be insufficient. So I would say it was wrong on that as well. But the treatment of causation, in my respectful submission, is not tenable. My learned friend referred to Amjad.
You'd have to say it was wrong, wouldn't you, on the exclusive, on your
Yes,
exclusive
I would.
interest
Yeah,
argument?
I would.
Yeah.
Yeah, because I would say in those things, control isn't enough, unless control means they're an intermeddler. But that wasn't the basis on which the judge reasoned it. My Lord Amjad, that's Mr. Justice Ritchie. I'm just going to deal very shortly. It's an extremely long case, and I really think most of my friend have spent quite a long time on it. But I'm not really sure his deployment of that case went much beyond the use of the word illusory in the context of the hire agreement. Really, what Mr. Justice Ritchie says about the nature of credit hire claims is a conclusion he comes to in circumstances where the hire company wasn't joined and made no submissions, so those points weren't explored. To the extent Mr. Justice Ritchie is holding a credit hire claim is not a claim brought for the benefit of the claimant, in my respectful submission, he is wrong for the reasons I've already addressed the court upon. My Lords, Ali and HSF, that's the reasoned order about cost. That case that was my fault for it is my fault for the inadequate way in which I explained what we were referring it to for in our skeleton. It's simply an illustrative point. I'm not remotely suggesting it's dispositive. But what happened in Ali and HSF, as my lady knows, is a case went to this court on the basis of an ex turpi causa defence. The appeal succeeded. After the appeal succeeded, it transpired the defendant had offered Mr. Ali more than the whole value of his claim in order to settle the appeal under Part 36. Mr. Ali said no, I was entitled to continue because I wanted to overturn the High Court precedent, which of course all these cases are in the county court, so High Court binds them. So it was an unhappy precedent for the hire industry. And this court says, we're not interested in that. It's Mr. Ali's claim. Mr. Ali was offered the full value of his claim. The Part 36 rules would apply in the usual way. Although he won, he pays the cost of the appeal. So all I say is, and that's just an illustration of this court very recently, just having adopted the classic Giles and Thompson Diamond and Lovell analysis. These are the claimant's claims. And I hope it isn't thought a sort of a complete make-weight to say the judgment in that case, the lead judgment, I assume therefore perhaps responsibility for the written reasons in Lord Justice Stuart Smith. Is a member of this court who not only has sat on these cases, but himself appeared in many of them. It's an area that he's extremely familiar with, and it's just the orthodoxy which comes out of his order. That's an orthodoxy Mr. Malidu is trying to change, and if you think it should be changed, I'm not stupid enough to think there's an order made on paper by this court, however eminent its constitution, is going to deter this court from saying no, with further argument, we've reached a different conclusion. But I do say it is illustrative that the position I'm adopting is not my position that's the outlandish one. And Mr. Malibu is showing you the admissions documents and so on and saying, all this is a sort of complex scheme in which to extract value from insurers. Of course, it's the credit hires claim in actuality. That's the unorthodox proposition, not what I'm proposing. So, my lords, that leaves me less than 5 minutes just to deal with the disposition of the two cases. In the DAMS case, my learned friends put great emphasis on the marketing documents from DAMS, an exo strictly. But all they show in my submission, and obviously I understand why my learned friend puts focus on them, but all they show is DAMS belongs to a corporate group that makes a profit from providing post-accident services to accident victims in an organised and efficient way. As I've said already, that just begs the question, well, if that's enough for an unparty costs order, then why don't we get cost orders against solicitors and barristers? Because if Irwin Mitchell or Lee Day, to take two prominent personal injury firms as an example, floated like DAMS did, like an AXA did on the alternative investment market, you would doubtless see precisely the same sort of statements in their admissions brochure. We bring cases on behalf of impecunious claimants under CFAs. Lee Day obviously makes an entire industry in running claims for people from less developed countries on CFAs who could never possibly pay them. Why don't they face non-party cost orders? Indeed, in some ways, Mr. Mallory's reliance on those documents, in the purest form, really, it exposes this difficulty in his submissions, because the one entity is referred to in those documents that is there making a direct profit out of litigation is Bond Turner, the solicitors. Yet they accept they can't get a cost order against Bond Turner when it acts no win, no fee for impecunious claimants. So on what basis, unless they are suggesting this law gives a special privilege to solicitors, and in my experience, at least, the courts are usually only too anxious to make the point they don't give lawyers favourable treatment. Unless he's saying that there is some special privilege for solicitors, how come he gets a cost order against somebody who was at arm's length from the litigation when he can't apply for them, and he accepts he can't apply for them for the party that was actually running the litigation, the non-party that was actually running the litigation in the sense of conducting it, and directly being remunerated out of its proceeds? In our respectful submission, in this case, the district judge's decision is exemplary. It's careful, it contains no legal directions, its findings of fact are not impeached. And I do say, and this is the one specific point I'll make, I'll otherwise rely on my skeleton, the position on causation in my respectful submission does make this appeal, and I appreciate it's a strong word, it makes this appeal hopeless. Because the district judge found in terms there was no causation of additional costs. Mr. Mallory does not appeal those findings as a matter of fact. All he can say, therefore, is that the district judge was wrong in law to take causation into account. But on the authorities Mr. Mallory has himself shown you, causation may not be jurisdictionally prerequisite. But every single one of those authorities, even his high watermark of total spares, says that causation is important. And we've since had the Supreme Court making that even clearer. And as I've said, even in total spares, you in fact have the different sort of causation, which is that the applicant was still able to show that they had been caused loss, and they cannot show that here. So that's that case. My lords, so otherwise, may I say, paragraph 66 of our Spectra skeleton contains a sort of point-by-point rebuttal of the criticism of the district judge, and I adopt that. My lords, in Spectra, I think the only thing I should, and I appreciate I may eat a minute into Mr. Mallory's time, obviously we forgot about the 2-minute silence. If I can just eat into that with the windfall point, as I've called it, or the good fortune point. That isn't an instance of the circuit judge embarking on a speculative hypothesis about whether a claimant who discontinued should be relieved of the consequences of discontinuance because their cases, in fact, had merit. With respect, it is obvious why the court discourages that, because the reason why the claimant is ordered almost as night follows day to pay costs in those circumstances is because they have elected to abort a process which they started. So, of course, in those circumstances, the court doesn't, barring exceptional circumstances, explore into whether maybe there's some deus ex machina or something that causes them to abort. But in general, you don't look into it. But that's not the position here. This is an application against a non-party. The defendant, the person complaining about the way the circuit judge treated matters, they elected to pursue the claimant as dishonest, and it was that pursuit which led to a judicial inquiry into the validity of the claimant's claim. That led to the claimant's claim, in fact, being validated. And so when the circuit judge comes to address the different question of whether the cost order unenforceable against the claimant should be transferred to the non-party, and asked himself, was it just? To suggest that he can't take into account that at the defendant's instigation, it's essentially raised judicata, a judicial finding, that the defendant had experienced an utter windfall because the claimant wrongly discontinued as a result of allegations of dishonesty that were exposed as completely misplaced, allegations misplacedly made by the defendant itself. To suggest that the circuit judge couldn't take that into account as a matter of law, in my respectful submission, is not tenable, and it clearly does not flow from the familiar authorities about the consequence of discontinuance. And may I lastly say that in the Gochner case, there was in fact a not completely unrelated point before my lord, because in Gochner a point was taken about the defendant. The defendant, I think, was in breach of an unless order, and so had been shut out of maintaining a claim for its costs. But my lord said, I think I quote precisely, something to the effect, it would be absurdly unjust not to take into account essentially that there had been a windfall to the party who was applying for costs, and but for that windfall, it would have been the net payer of costs, not the net beneficiary of the cost order. And that's the Gochner case at paragraphs 70 to 71. So there is an actual instance of a court, and of course my learned friend in other points in his submissions is saying, look at the reality. Well, if the reality of this case is that there should never have been a discontinuance and it resulted from a misplaced allegations of dishonesty that were later rejected by a judge, to suggest that in those circumstances it's not just to require a non-party who had no connection to the discontinuance whatsoever to pay the defendant's costs, that's not open to the judge as a matter of law. In my respectful submission, that can't be right. My lords, those are my submissions, and my lady.
Thank you very much. Yes, Mr. Maloney.
My lady, my lord, I have, I think, just over 10 minutes to deal with replies. Obviously, any points I don't specifically address are not to be taken to be any agreement to the points made by my learned friend. We rely on the submissions we've already made and the contents of the skeletons. My lord, the first point is that the core, or at least the core of much of the respondent's case here, rests on the proposition that it's a consequence of the accident that's the trigger for these claims, that the claimant has lost the use of their vehicle, and that the claimant has a claim for that, which, but for the credit hire agreement that they enter into, might have been brought and might have been quantified in some way by reference to the notional hire of an alternative vehicle. And therefore it's said it's wrong to regard the credit hire claim as being brought for the financial benefit of the credit hire company, because absent the credit hire, the claimant may have brought some claim in any event which may have been quantified in some similar or lesser way. We say, whilst a great deal of time was spent on that by the respondents, there is in fact a simple and fundamental flaw to that argument. Yes, a claimant might have had a loss of use claim. Yes, a claimant might have brought such a claim, and yes, that claim might have been quantified by reference to basic hire rates or some other measure. But may or might is not the issue. The court does not determine costs in a claim by reference to the case that a party may or might have brought, but by reference to the claim that was brought and the circumstances and consequences of that claim. So we don't know if these are any of the other claimants in these types of cases would have brought loss of use claims or not, or if so, on what basis or for what sums. We do know that they did sign credit hire contracts, and the claims they brought, or the core part of the relevant claims, was a credit hire claim for credit hire costs at full impecunious rates on, as we've already seen, an effective non-recourse basis, where, for reasons I won't repeat, the claimant, we say, is effectively obliged to do so, subject to what we say are the effective sanctions contained within the contract if they don't comply, and we rely on the analysis already given and the analysis conducted in Amjad in particular, but also Kinderton's and Select in that regard. And it's on the effective basis, as we've already seen, for reasons I won't repeat, that the claim in essence is to be pursued until a settlement which is likely to be satisfactory to the credit hire company is achieved, because if the credit hire company is satisfied, the claimant, the impecunious claimant, will not be pursued otherwise, and of course her solicitors, given their experience of these cases, are likely to be in a position to explain whether or not the credit hire company is likely to be satisfied. We don't know, therefore, whether any other claim would have been brought. If so, how it would have been quantified. If it would have been contentious. If it was a simple loss of use claim or on basic hire rates, it may well not have been contentious and not disputed. But we say none of that matters. We must look at the claim that was brought, and for the reasons that we have given and for the reasons that we say are supported by the authorities, that is a claim where it can be properly seen that it is brought in the primary financial interest of the credit hire company. And we say once this is recognised, we can then make proper sense of the decision of this court in the case of Farrell. We can make proper sense of the contents of CPR 4416. We can make proper sense of the practice direction, and we can make proper sense of the decisions of the High Court judges that we have seen. And the idea, of course, that in Farrell, for all of the attempts by my learned friend to play down the decision in Farrell, the idea that in Farrell, the constitution of that court, including the Chancellor, after the cases of Giles, Dimmond, Lagdon, and B. and Jensen, were not aware of the basis on which credit hire claims work, and the idea that the claimant had to have a liability to the credit hire company is a plain nonsense. They must have understood that, but nevertheless they concluded that it was appropriate to make the credit hire company liable for the non-party costs. Once that point's disposed of, we say, the central plank of the response to this appeal falls away. Apologies for the slight whistle-stop tour, but the second point we make, my lady, my lords, it is just to address briefly the point that credit hire claims do generally, and I'm addressing here the points at generality, add to cost and complication. Mr. Williams referred to the small claims track and to personal injury aspects of the claim, taking the claim out of the small claims track. But he acknowledged that it's rather more complicated than that, but didn't have time to explain further. It is, of course, considerably more complicated than that. Your lordships will be aware that for many years, dating back now since 1999, low-value personal injury RTA and RTA claims have been dealt with through the RTA protocol, and the aim of that protocol is to ensure such claims are dealt with proportionately. Vehicle-related damage aspects of such claims are usually dealt with outside the protocol, but that's because, as Mr. Williams touched on, there are industry agreements there, including the GTA, aimed at minimising costs. But those agreements will not usually bite where there are claims for full credit hire rates, even if all of the parties are subscribers to them, which some of the credit hire companies are not. And what then happens is these claims fall out of the protocol, and the consequence of that is that it substantially increases the costs. And this is not just me saying that. I'll only, in the interest of time, give your Milady and Lords the reference, but I do invite you to turn it up. In the DAMS supplementary bundle at page 94, there is a paragraph headed Regulatory Changes, where Annexo itself refers to the protocol and itself states that the majority of the group's claims fall out because the credit hire charges are contested, and that this puts them in a higher cost process with greater legal fees. We also rely specifically in terms of facts on His Honour Judge Gargan's factual findings in Spectra as to in whose interest the claim was being brought. And just for your Lordship's reference, my Lady's reference, that is the Spectra main bundle, page 131, paragraphs 174 and 175.1 to 175.3. The third point we make is that it's not an answer, of course, to say in that context that the additional costs are the insurer's fault for taking such points. It's important to remember that when we're considering non-party costs...
Sorry, what was your heading again for this third point?
That it's not an answer to this to say that it's the insurer's fault for taking such points. When we are considering whether non-party cost orders should be made in this context, we are, of course, only considering the cases where the claims have failed, either in whole or substantial part. For example, the credit hire element fails and therefore Part 36 offers aren't bettered. By definition, the claim or the relevant part of it has failed. And whilst a lot of time was spent by my learned friend in Giles and Thompson, he only briefly touched on one of these extracts and didn't touch on the other. Twice in that case, Lord Mustall refers to the protection available to insurers faced with credit hire claims from the ability to recover costs from the credit hire companies. And that is Authorities Bundle, page 74, letters G to H, and Authorities Bundle, page 88, letters A to B. And whilst Mr. Williams tried to suggest that that wasn't a reference to necessarily obtaining costs against the credit hire companies, in my respectful submission, he's wrong about that. And indeed, the first of those citations expressly refers to costs being ordered against what Lord Mustle refers to as the maintainer, by which he's plainly referring to the credit hire company. The fourth point is Mr. Williams' false equation of this claim, and I understand entirely why he does it, of these issues with cost orders against solicitors. He is entirely correct, and there's nothing between us, that it's generally well established solicitors are not vulnerable to non-party cost orders merely for acting on CFAs, and you have the Hodgson case in your bundle. However, it is a false equation to then compare that with, and now I understand why he used the term no-win, no-fee credit hire, with no-win, no-fee solicitors. There are four main reasons. Firstly, the solicitor is providing access to justice by acting for the client under a scheme expressly approved by Parliament for that purpose. That's Section 58 of the Coulson Legal Services Act. And that is addressed in the Hodgson case, Authorities Bundle 197H to 199A. The second is that the solicitor is bound to act in the client's interests regardless of their no-win, no-fee agreement, not in their own interests. That is addressed by the Court of Appeal in the Hodgson case, page 199, letters B to C. That, of course, is a fundamental distinction to the position of credit hire companies. The third is the solicitor is acting for the client in relation to the client's claim. The solicitor is not the genesis of the claim. The solicitor's fees are not the subject of the claim. And the fourth is the contract entered into by the client with the solicitor does not bind the client to pursue their claim. It is a contract to provide facilities allowing them to pursue their claim, not binding them to pursue a claim. So it's a false equation. I think I have 1 minute left in which to make 2 points, so I'll have to be quick. Point 5 deals with the issue of combined issue, I'll lump the two together, exclusive interest and causation.
Yeah.
And what we say here is that Mr. Williams' arguments are impossible to reconcile despite his attempts to do so with one of the key areas where non-party cost orders are routinely made, which is third-party funders. And we don't equate credit hire companies with third-party funders, which is what we said we were attempting to do. We simply use the position in relation to third-party funders to show that the respondent's arguments in principle fail. First sub-reason to this is it cannot possibly be suggested that a third-party funder has the exclusive interest, and that was central to Mr. Williams' argument.
No, they're its betters.
I'm grateful for Mr. Williams' interruption, because the one authority you have in the bundle, which is Excalibur, which is Authorities Bundle page 476, letter F, it is plain in that case that Lord Justice Hamblin is approaching the question of liability of third-party funders on the basis that they are a real party.
Yeah.
So we're therefore saying Mr. Williams' argument of exclusive interest, which I note he later modified without explanation to near exclusive interest, doesn't hold good. The second is that similarly on a causation basis, and Mr. Williams responded to this, but in my submission didn't give a good response, a strict but-for causation test is not, or at least in my submission, not conventionally applied, and Mr. Williams, I didn't understand to dispute this, in respect of non-party cost orders against third-party funders. And that's an illustration that causation is relevant, but as I think Mr. Williams in fact accepted in places, not a sine qua non. I also refer your lordships to CPR 25.28, which is the position for security for costs when sought against third-party funders, which refers to the ability to seek security for costs simply on the basis that providing funding in return for a share of recovery. And again, this helps square the circle with the decision in Farrell and otherwise. The final point, and I apologise, I'm 2 minutes over it, but I'll be no more than about a minute and a half. The final point is in relation to CPR 4416 PD12, and I'm helped in being shorter by the intervention of my Lord Justice Birss when this point was addressed by Mr. Williams. The first point is that we only get to PD 12.5a where there is a personal injury claim which includes a claim for the benefit of another person. And that is the express words of CPR 4416 2a. We then get to 12.5a, and the key point is that we can see from that that a strict but-for causation test is not being applied, and this is in part for the point raised by my Lord Justice Birss, because it refers to the non-party being ordered to pay all the costs of the proceedings or the costs attributable to the issues. And Mr. Williams' argument that that might be right, for example, in the context of a wholly subrogated insurer claim simply doesn't wash, because you wouldn't be here in a wholly subrogated insurer claim because there'd be no personal injury. The whole premise of this part of the rule and the practice direction is the claimant has to have a personal injury claim, but within the claim there is an element in relation to a third party. So you wouldn't be here if all of the proceedings were the third parties. You only are here because the claimant has a personal injury claim and there is included within it an element for a third party. But we say that wording it is indicative that a strict but-for test is not applied, and we say that's indicative also from the rest of the wording of the practice direction, which makes it clear that the court can attribute the costs on the basis of what is just, an overall test of justice. And we say when that is understood, again, we can then square the circle with the total spares and the Turville cases. And even Mr. Williams, I think, accepts the strict but for would the cost have been incurred test can't be the test because that wouldn't square with those cases. And we say that that is indicative that in fact the test is a broader one, and it comes back to the only immutable principle being what is just in all the circumstances. Lord, my lady, there are other points I would like to make, but time does not allow, and I'm very grateful that you've been kind enough to allow me the extra few minutes to make the points I did, unless I can assist with any questions.
No, thank you very much. Right, well, thank you both very much. Thanks to all of those sitting behind you. Speaking for myself, the day and a half has flown by. But that's as a result of the extremely careful preparation of the case. So we are very grateful to everybody, and we understand the potential importance of the judgments. That's one of the many reasons why you'll be unsurprised to learn we will not be giving an extempore judgment. We will reserve our judgments, and they will be provided in due course. They'll be provided in draft, as you both know, and that's an opportunity to correct our grammar and our typographical errors, but it is not an opportunity to re-argue the case. The drafts will be provided to those whose names have been provided to my clerk. I think that's already happened, but you could both make sure that it has, so as to ensure that the people who have it are limited, because it is a privileged document until judgment is handed down. If once you get the draft, there is the need to consult with somebody within the client organisations that haven't been identified, then by all means seek permission from the court. But you can take it that permission will almost certainly be granted.
Thank you, my Lord.
Once you have digested the draft judgment and commented on the typos, we would hope that you'd be able to agree the consequential order. And if so, then that can be provided to us. If there are points of difference on the order, substantive points of difference on the order, then the best thing to do is to provide a copy of the order with old-fashioned, multicoloured, different versions, one in red, one in green, something like that, and to provide short, and I mean short, submissions on the points of difference. We will decide those on paper, and so there will be no need, you will provide those short submissions, we will decide it. There will be no need for a further hearing, and of course there'll be no need for attendance at the hand down, which will be electronic. All right, thank you all very much.
Thank you, my Lord, my Lady.
All rise, table.